Good morning, everyone. We're going to get started. My name is Catherine Liberty, and I'm from the Commission's Office of the General Counsel. We're happy to welcome you to this one-day Commission staff-led technical conference to discuss methods natural gas companies may use to mitigate the effects of direct and indirect greenhouse gas emissions resulting from projects authorized under Sections 3 and 7 of the Natural Gas Act. Before we begin with opening remarks, I wanted to outline some logistics for the conference. We will have 2 panels this morning, followed by a lunch break, and 1 panel this afternoon. We will also have a 15-minute break between the morning panels. Only the commissioners, panelists, and a small group of commission staff will have speaking roles today. The conference is being webcast and transcribed. I would also like to remind all participants to refrain from any discussion of pending contested proceedings. If anyone engages in these kinds of discussions, a FERC staff member will interrupt the discussion to ask the speaker to avoid that topic. With those initial matters out of the way, I will now turn it over to Chairman Glick to begin this conference.
Well, thank you very much, Katie. And I want to thank you and the team for putting together this very timely and I think this could be a very interesting technical conference. And I also wanted to thank all the panelists. I always say this, and it's true. I know you're all giving up your time, and really appreciate it because you're contributing to our record. And I want to specifically call out Commissioner, former Chairman Kelleher, who was chair of this commission, I believe, between 2005 and 2009. And it's always nice to see him, and I appreciate him coming back and participating today. I've been at FERC almost 4 years now. And we have had quite a number of debates about the Natural Gas Act and about the pipeline certification process. And one of the big areas of disagreement, of contention, has been what to do with the project's greenhouse gas emissions, both direct emissions and indirect emissions. That's both in terms of Section 7 pipeline certificates, but also Section 3 on the LNG field as well. And it's always been interesting to me because, in my opinion, we've treated greenhouse gas emissions differently than every other environmental impact associated with the proposed pipeline. And we essentially haven't reviewed those emissions under NEPA and under the Natural Gas Act, in my opinion. And I think in many cases it's led to some vulnerabilities in our decision, in our commission orders. And if you look at the court decisions, and I would challenge anyone to read them otherwise, if you look at Sable Trail, you look at Burkhead, you look at the CNEOS with regard to LNG facilities, I think the D.C. Circuit has been pretty clear that we are supposed to review and consider in our decision-making processes reasonably foreseeable greenhouse gas emissions. Now, the question is, how do you do that? And how do you treat them, greenhouse gas emissions, as any other environmental impact? And, for a while there, the majority of the commission said, no, we're not going to do it at all. And then more recently, in the Northern Natural case, a majority of commissioners, and I was one of them, determined that, yes, that we need to consider greenhouse gas emissions. We need to consider the impact on climate change, and we need to consider them in the context of both NEPA and the Natural Gas Act. And, I think a lot of people are nervous about this, and in the industry, and I understand it's relatively new from a commission perspective, and there's a whole variety of issues that need to be addressed. And I would just make the case that I think what we're doing here is creating greater certainty for industry. If you look at the numerous now court decisions on Natural Gas Act cases, whether it be on greenhouse gas emissions or NEET or whatever else, it's very clear that when we don't do our job, when we pursue the certification process or the LNG process, the courts are going to send it back to us. In some cases, they'll vacate the commission orders. In some cases, they'll just ask us, they'll remit it back to us and consider it for further consideration. But nonetheless, that adds billions of dollars in many cases of extra time, extra cost, extra time. And in some cases, we've seen projects terminated because of court decisions in terms of overruling agency decision making. So I really look forward to this discussion today because I think that the issue of mitigation, of how we're going to pursue mitigation, just like we do with every other environmental impact, is going to be a big part of this commission's agenda going forward. And like I said before, I think we're going to create greater certainty, not less, if we pursue this, and we pursue it in a responsible manner. And I think the discussion today is going to lead us in that direction. So with that, I want to turn it over to my colleagues for their opening statements too, and we'll start with Commissioner Danley.
Thank you, Mr. Chairman. I question the possibility of establishing the kind of certainty you're talking about when we still have outstanding and is good law the Supreme Court's decision in Public Citizen, which I think a lot of the cases that you cite tend to cut against. And we have yet to see what the ultimate result of the collision of those two sets of case law is going to be. So I don't really know what decisions it is that we're going to make here that appear to fly in the face of the legal proximate cause analysis in Public Citizen, knowing that that could ultimately be proven to be the law of the land, as you and I have talked about, and as I read the law. And on that subject, I think that this entire technical conference presupposes the threshold question of whether or not it is legal to get into any type of mitigation under our conditioning authority, which presumably is the mechanism that would be contemplated to achieve it. And I'm not certain that any conditions that would be imposed that are outside the normal remit that we have seen ourselves having for the last 100 years of the NGA, I don't see how that can possibly add to any certainty either. The conditioning authority has been relatively narrow. The statute speaks of reasonable conditions, and a drastic departure from 100 years' worth of the history of the NGA. I am not certain at all that we have the authority to do this. This is especially true given the fact that FERC's role in executing the NGA is to ensure the plentiful supply of natural gas at reasonable prices. We are an economic regulator. We are not an environmental regulator. The EPA has, in the first instance, the authority to conduct this sort of analyses and impose the sort of regimes that I think are being contemplated here. So my hope is that even though it is not directly the subject of the questions for this morning's discussion, any panelists that would like to discuss the subject of our legal authority, I would be grateful to hear their thoughts on the subject. Thank you, Mr. Chairman.
Thank you, Commissioner Daly. I will be grateful as well, and I'm really glad to have that debate. I think it's very clear. Commissioner Clements, you're next.
Thanks, Chairman Glick, and thank you for putting together this important conference. In my mind, it is an important step on the path towards one of my primary goals, which is to revise our 1999 policy statement on the certification of natural gas facilities. We should be accounting for the factors that bear on the public interest today and the foreseeable future. Much has changed in the last 20 years, beginning with the dramatic adverse impacts of climate change, which too often fall disproportionately on environmental justice and otherwise disadvantaged communities. We can continue to talk and nitpick through each of these court cases that keeps coming down and say, no, that was unreasonable. It wasn't on the merits. It was simply a decision that the Commission failed to not provide the proper reason or the proper dynamic. It keeps happening, and so we can continue to, we can continue to have this legal discussion, or as a practical matter, we can say, we're in a different place than we were in 1999. Let's do a better job. Let's update our process. Let's provide regulatory certainty in a way that stops this conversation about nitpicking through the court decisions that have come down. In my mind, in determining whether to approve new natural gas facilities, I believe that the first gating question is project need. If a developer of a proposed interstate natural gas pipeline facility cannot demonstrate that the facility is needed, then there is no basis for the Commission to issue a certificate application. And I want to be clear that I'm thinking about how climate change may bear on the broader need determination. For example, should the Commission assess the risk that current demand for transportation of natural gas will dissipate as federal, state, local governments respond to climate change by restricting the use of some use of fossil fuels? How will future technologies such as green hydrogen affect the demand for the service on natural gas pipelines? As more variable generation comes onto the power grid, what role will the proposed natural gas facilities that we're considering play in supporting that integration? Appreciating that it's difficult to fully separate out these questions from the mitigation discussion, I am looking forward to learning more from today's panel about options for quantifying and mitigating GHG emissions associated with Commission-authorized pipelines. I'm interested in specific, concrete, and pragmatic approaches to quantifying and mitigating the GHG emissions. I feel very fortunate that we have such a highly qualified group of panelists sharing their insights with us today. It is always an honor to have a former commissioner and chairman participate, so thank you, Chairman Kelleher. And for me, it's also an honor to have, personally, have Stu Tierney participating in this panel as well. But thanks to all of the panelists today, I really look forward to hearing what you have to say. Thanks, Chairman.
Thank you, Commissioner Clements. Commissioner Christie?
Yeah, thank you, Mr. Chairman. Just very briefly, I do agree with Commissioner Clements on the statement she made that if a natural gas pipeline or other infrastructure needs to be built, that's the threshold question in a CPCN proceeding. The N stands for need. And if we find that an infrastructure project is needed, then it needs to be built. And I will, at that, turn it back to you, Mr. Chairman.
Okay, thank you, Commissioner Christie. I'll turn it back to you, Katie, to get us started.
Thank you, Chairman Glick and Commissioners Stanley, Christie, and Clements for providing opening statements. We also appreciate your attendance at this conference and want to welcome all of the panelists again. Our first panel is entitled, The Level of Mitigation for Proposed Projects Reasonably Foreseeable Greenhouse Gas Emissions. Panel 1 will run through approximately 11 o'clock this morning. Again, my name is Katie Liberty, and I work in FERC's Office of the General Counsel. I'm joined this morning by my colleague and co-moderator, Matt Christensen, the Commission's General Counsel.
Thank you, Katie. I appreciate the opportunity to be here and help moderate the panel today. We're looking forward to a lively discussion, I think you can call it, between the panelists. And to that end, Katie and I will ask your questions, but we may also jump in, play devil's advocate occasionally, or ask a hypothetical. As is already clear, I think this is a question that our commissioners and chairman have spent a lot of time thinking about as well. So I suspect they'll jump in at points throughout the morning too. With that, I look forward to it. Let's get to the substance. Over to you, Katie.
Thank you. We remind all participants to refrain from any discussion of pending contested proceedings. If anyone does engage in these kinds of discussions, Karen Larson from our Office of the General Counsel will interrupt the discussion to ask the speaker to avoid that topic. Our first question will be addressed to all of the panelists. I will call on each panelist in turn to give their response. I ask that panelists limit their initial response to no longer than 3 minutes. When considering greenhouse gas emissions from a proposed project, should the Commission evaluate mitigation for direct and indirect emissions, such as downstream emissions, in the same manner? First, we'd like to hear from Dr. Susan Tierney, Senior Advisor at the Analysis Group Incorporated. Dr. Tierney.
Thank you so much. I very much appreciate this generous invitation to allow me to participate on this panel, and I appreciate that the Commission has decided to hold this technical conference on such an important issue. For the record, I would like to say that I'm speaking on my own behalf and not on behalf of others at Analysis Group. So, should the Commission evaluate mitigation for both direct and indirect emissions in the same manner? Well, first, the Commission should count up direct and indirect emissions as part of its environmental impact analysis in the same way. The only reason that an applicant wants to build a natural gas facility is because of the intention to move gas from the places it's produced to the locations it will be consumed. The delivery of gas is an essential element of this supply chain, and emissions that directly result from construction and operation of the jurisdictional facilities are only a portion of the emissions resulting from the supply chain. The Commission should therefore count up emissions along the supply chain in the same manner, relying on reasonable estimates of such environmental externalities. Secondly, the applicant should take reasonable and appropriate steps to mitigate the direct emissions from the project as part of the environmental assessment under NEPA. And then finally, if after the comparison of a project's benefits against its adverse impacts and costs, if the Commission then determines that it is in the public's interest that the facility be certificated, in spite of any remaining unmitigated adverse impacts, the Commission should then use its conditioning authority to introduce any requirements to minimize environmental impacts of the project as necessary under the public interest test. Thank you.
Thank you very much, Dr. Tierney. Next, we will hear from Mr. Scott Hallam, Senior Vice President of Transmission in Gulf of Mexico at Williams. Mr. Hallam.
Good morning, Katie, and good morning, Commissioners. Thank you for the opportunity to putting this panel together. Williams has had a strong track record of partnering with the FERC as it relates to development of understanding around greenhouse gas downstream emissions. We've been working with the FERC for the last several years and other stakeholders around how to quantify downstream greenhouse gas emissions along with direct emissions along our pipeline. I believe that before we can dive into the question of mitigation, we have to continue to challenge ourselves around the quantification of direct and indirect emissions. Pipeline projects serve a multitude of different purposes and needs, some for incremental demand, others for resiliency and reliability. And so when we think about the complexity of the natural gas network, truly a spider web of infrastructure that's serving the markets here in the United States, and I would say probably one of our strongest resources we have around the we have to understand that an overly simplistic solution can impact the complexity of the natural gas system. So as we think about the quantification, we have to ensure that we're taking into consideration how natural gas projects are designed. And I know this isn't a new concept for this discussion, but many projects are designed around the basis of peak demand usage, whether it be in the the winter heating season or the summer cooling season. In those several days and weeks within those seasons where natural gas infrastructure is truly delivering the energy that was designed for that project. And as we think about how to quantify a project, taking into consideration the load factor across a full 12-month, a rolling 12-month period, is very different than a load factor or full burn scenario that really addresses a very short period of time, although an extremely needed period of time for that natural gas infrastructure. Another aspect is just resiliency, as we're seeing natural gas infrastructure being used in different markets and ensuring that those markets have natural gas that they can count on day in and day out. And so how we quantify the downstream greenhouse gas emissions when pipelines are there to serve with resiliency and reliability, I think that's another challenge we have around downstream greenhouse gas analysis. Lastly, I would say are the characteristics of how the downstream market utilizes the natural gas that's being delivered. And how we see fuel switching taking place, retirement of power generation from higher carbon fuel sources to lower carbon fuel sources. As an example of where we're seeing, the downstream greenhouse gas analysis and offsets associated with those activities needing to be factored into that quantification process. So we believe that there's a healthy discussion that needs to take place around the quantification, and once that conversation takes place, then endeavoring into, if mitigation is appropriate. Again, at Williams, we appreciate this discussion. We think that this needs to be a series of conversations, and we, as Williams and our industry, are very serious about participating and progressing into a clean energy economy. Thank you.
Thank you, Mr. Hallam. Next, we have Maneen Naismith, Senior Attorney at Earth Justice. Ms. Naismith?
Thank you. Good morning, everyone. I just want to start by really expressing my gratitude to the Commission for holding this panel and for allowing me to participate. I also want to issue a quick disclaimer that My colleagues and I at Earth Justice often represent many clients in many proceedings before the Commission. I'm here today in my personal capacity and do not speak for any of my clients in the remarks I'm going to make today. As one of the lawyers on the panel, I just want to start by saying I would be delighted to discuss the legal questions Chairman Glick and Commissioner Danley have raised in greater detail on the Commission's authority to regulate greenhouse gas emissions. I would wholeheartedly agree with Chairman Glick's view that the law is in fact clear and that both direct and reasonably foreseeable indirect effects of any project before FERC must be considered. And in fact, that the public citizen case does not cut in the other direction. Taken out of context, as has been done in many cases in many briefs, public citizen can be quoted selectively to suggest that there is a breaking of the causal chain and that upstream and downstream greenhouse gas emissions for FERC projects do not need to be considered. However, that if you take a step back and look at what the public citizen case in fact was about, it was about whether or not an agency needed to consider under NEPA an effect that it could have absolutely no way of changing at all, not regulating, changing. The issue there was that the Department of Transportation was not in charge of authorizing the activity that was going to start truck emissions. They were simply in charge of paperwork. And therefore, the court said there was no reason for them to do a NEPA analysis. Here, it is undisputed that if FERC approves a pipeline, there will be downstream emissions. If FERC approves a pipeline, there will be upstream emissions as a result of that pipeline. And so by not approving the pipeline, the Commission very much has control over those emissions and therefore fits very comfortably within the public citizen precedent. In terms of the approach to mitigation, I would agree with Dr. Tierney's statements that we need to accurately account for the entire life cycle emissions of a project and that the significance of those emissions need to be determined in order for the Commission to know what problem they are trying to mitigate and solve for. Mitigation, though, needs to be done if we get there, it needs to be done on a case-by-case basis, depending on the source, size, and significance of the emissions, among other factors. But certain broad principles can be adopted. For example, given the extent of the climate crisis, the need to avoid not just new emissions, but reduce existing emissions, the Commission should be putting a thumb on the scale in favor of mitigation measures that eliminate greenhouse gas emissions wherever possible, and put the burden on the applicant to rebut the presumption with concrete evidence that shows that such measures might, in certain instances, be technologically or otherwise infeasible. For example, FERC could require and have a presumption in favor of electrification of operational and construction equipment. And an even greater weight should be placed in favor of mitigating where that mitigation would have co-benefits to prevent additional pollution from being imposed on environmental justice and tribal communities that already are suffering far too high a burden from pollution. The Commission also needs to very seriously, however, consider that their ability to mitigate some of the greenhouse gas emissions from the projects it considers may be more limited. And in those instances needs to give very serious consideration, and in any instance where greenhouse gas emissions from its projects will be significant, to denying the project. The Commission, it is clear from the case that the Commission has the authority to do that. And in the light of the extent and the existential nature of the climate crisis, this option the Commission needs to very, very seriously consider before assuming that mitigation is possible or desirable and in the public interest or public convenience necessity. Thank you very much.
Thank you, Ms. Naismith. Next, we have Honorable Joseph T. Kelleher, Principal at 3 Acorns. Chairman Kelleher.
Thank you, Catherine, and thank you for the invitation. I'm going to take Chairman Glick up on his invitation to address the legal questions because I don't believe that FERC has legal authority to impose mitigation for either the direct or indirect emissions associated with the proposed pipeline. The legal basis for FERC imposing mitigation presumably is the Commission's conditioning authority and its legal authority under the Gas Act to protect the public interest. But I think there's problems with that approach. While public interest appears to be a broad term, it actually is quite limited. The Supreme Court and NAACP held that the term public interest is not a broad license to promote the general welfare and the term takes meaning from the purposes of the regulatory statute. So public interest is limited to the purposes of the Gas Act. The court stated that the principal purpose of the Gas Act was to encourage the orderly development of plentiful supplies of natural gas. If imposing mitigation discourages or forestalls pipeline development, the policy is directly contrary to the principal purpose of the Gas Act and must be set aside. It also can't reasonably be argued that the Commission's conditioning authority is unlimited. It too is cabined by the purposes of the Act. And courts have repeatedly found that FERC's conditioning authority is limited in a way that the Commission does not have authority to impose conditions in areas that are reserved to states, and the Commission does not have authority to use its conditioning authority to insinuate itself, that's the court's term, not mine, into areas reserved to other federal agencies. There's no question also that the Gas Act is not an environmental statute. The word environment appears in the Act in a grand total of 3 places, none of which are substantive, all are cross-references to NEPA. But the Commission would transform itself into an environmental agency with this proposal. Courts have looked with great skepticism on agency reinterpretations of old and unheralded statutory provisions, like conditioning authority, to produce large-scale increases in regulatory power. And while today's technical conference is focused on mitigation of proposed projects, it begs the question of whether the Commission believes it has authority to impose mitigation on direct and indirect emissions attributable to existing pipeline facilities. Recent Commission actions suggest the Commission believes it can modify a certificate after issuance. If so, it could impose mitigation for direct and indirect emissions associated with existing projects. I think there's another specific reason why I don't think the Commission has legal authority to mitigate the direct emissions from pipeline operations, namely the fact that such emissions are subject to regulation by EPA under the Clean Air Act. EPA recently issued a proposed rule to regulate methane emissions, including emissions from pipeline facilities. If EPA is regulating greenhouse gas emissions from pipeline facilities, on what basis would FERC indirectly regulate the same emissions from the same facilities owned by the same companies, only differently and more strictly? If the effect of EPA's rules were to reduce methane emissions at pipeline facilities by 30%, on what basis would FERC require 100% reduction? And to be clear, I'm not saying that greenhouse gas emissions cannot be considered under the Gas Act, but I think that consideration must take a different form than imposing an arbitrary mitigation level, and I'm happy to discuss that further. I also think I have some ideas of constructive alternatives that are legally durable, unlike the proposed mitigation policy, that can, I believe, produce greater greenhouse gas emission reductions than the contemplated mitigation policy. With that, thank you for the invitation. Look forward to questions.
Thank you, Chairman Kelleher. Next, we'd like to hear from Ms. Jennifer Danis, Senior Fellow at Columbia University Savin Center for Climate Change Law. Ms. Danis.
Good morning, and thank you for this convening. With respect to legal authority, the public convenience and necessity standard was never a proximate cause inquiry, nor was it ever deployed in a manner that circumscribed what the Commission could consider. And the Commission's predecessor, the FPC, knew this and knew that it needed to consider air impacts under the NGA well prior to and apart from what NEPA later required. As a matter of course, FPC decisions from as far back as the 50s and 60s routinely evaluated how natural gas transported via a proposed project would be used and assessed the air quality impacts of that use. As early as 1966, the FPC refused to certify pipelines, in part when there was insufficient evidence that they would improve local air quality. In fact, the FPC recognized that air quality impacts of natural gas is one of the most important factors to be considered under Section 7 of the NGA, and expressly rejected claims that environmental statutes enacted after the NGA that made other entities solely responsible for addressing air pollution would somehow infringe on its authority to determine whether increased natural gas use could, in some instances, help combat air pollution. I'd like to think we've come a long way since then, and the Commission's authority hasn't narrowed, although our view about the use of natural gas to help combat air pollution really needs to be examined on a case-by-case basis. So with that said, the Commission should evaluate mitigation for direct and indirect emissions, including full burn, downstream, and upstream emissions in the same manner and in the same analytical step after it determines that a project serves the public interest because the documented benefits outweigh the measured and contextualized harms. After determining that a particular project is required by the public convenience and necessity, meaning that the full accounting of unmitigated harms are outweighed by the full accounting of public benefits, the Commission can use its broad conditioning authority to place conditions on the certificate that can minimize and mitigate the project's greenhouse gas emissions to the full extent possible. For those associated with direct emissions, Commission conditions could require specific technological measures, ongoing monitoring compliance, and with provisions to ensure that emissions remain at anticipated levels, amongst other conditions. These conditions are fully consistent with the myriad conditions that the Commission currently uses to ensure that its authorization serves the public interest. While the Commission has full authority to condition certificates with mitigation measures to ensure that the project is required, that the project that's required by the public convenience and necessity continues to serve the public interest, it can account for and attempt to mitigate upstream and downstream emissions. But as industry has pointed out, it does not regulate those facilities or uses generating those emissions. Thus, its evaluation of which mitigation conditions it can apply will look different and require a more skeptical eye. But this, of course, is a foundational reason for why the Commission has to evaluate those mitigation measures in the proper analytical step as harm reduction measures that attempt to reduce the project's impacts that may not meet their intended goals. Enbridge's comments, for example, as well as my own, highlight the many reasons why mitigation measures are far from certain to achieve their goals. Recent EIA estimates showing over 4 billion cubic feet per day of new natural gas pipeline capacity entered in the third quarter of 2021. At a time that we know that committed emissions already exceed our climate change needs. We are awash in gas infrastructure. What we have, we must use more efficiently. And the Commission's focus here today on more carefully analyzing all possible alternatives to building new infrastructure and carefully accounting for the greenhouse gas emissions will move us towards that goal. Thank you.
Thank you very much, Ms. Stanis. Next, we'll hear from Patricia Outram, President of Outscan Resources. Ms. Outram.
Thank you very much for this opportunity. Good morning, Commissioners. When it considers whether or how to analyze and require mitigation for potential greenhouse gas impact in its review of a project, the Commission should recognize climate change as a global phenomenon and adhere to the limited scope of its jurisdictional authority. The upstream source of the natural gas and the downstream destination is often unknown and may change throughout the project's operational lifetime. Given the limitations on the Commission's ability to identify, model, and quantify greenhouse gas emissions, it cannot adequately assess the impact or the significance of those impacts caused by a particular project on climate change. Under the Council of Environmental Quality's current regulations, but-for causal relationships is insufficient to make an agency responsible for a particular effect under the National Environmental Policy Act. CEQ guidance provides that effects should not be considered if they are remote in time, geographically remote, or the product of a lengthy causal chain. Moreover, effects do not include those that the agency has no ability to prevent or that would otherwise occur. For example, the environmental effects resulting from natural gas production generally are neither caused by a proposed project nor are they reasonably foreseeable consequences of its approval. To date, the Commission has correctly found that upstream emissions are neither reasonably foreseeable nor causally connected to a project. The scope of the Commission's jurisdiction under the Natural Gas Act clearly does not include jurisdiction over emissions. Moreover, there are no established benchmarks quantifying the amount of greenhouse gas emissions or percentage increase in greenhouse gas emissions the Commission should consider as adversely affecting the environment. To date, the Commission staff has not identified a methodology to attribute discrete, quantifiable physical effects on the environment resulting from a proposed project's incremental contribution to greenhouse gas emissions, as the models currently available cannot determine incremental impacts of individual projects. Without the ability to determine discrete resource impacts, the Commission staff has been unable to assess a project's contribution to climate change through any objective analysis of physical impact attributable to the project. Additionally, the Commission staff has not been able to find an established threshold or determine a project's significance when compared to established greenhouse gas reduction targets at the state or federal level. Given its inability to determine a project's contribution to climate change and thus the significance of such contribution, the Commission should not impose on applicants a requirement to mitigate for such effects. Quite the opposite. Natural gas can and should play an important role in reducing greenhouse gas emissions worldwide. The U.S. power sector has decreased greenhouse gas emissions by 12% since 1990, largely through the switching to natural gas for power generation. Furthermore, when natural gas displaces coal and oil for electric power generation, it not only cuts greenhouse gas emissions, but also reduces nitrogen oxides, sulfur dioxide, and particulate matter. In the full life cycle analysis comparing natural gas-fired power to coal, natural gas results in half or less of the greenhouse gas emissions from coal. Therefore, proposed LNG export projects will actually reduce greenhouse gas emissions globally. Virtually all sectors of the natural gas value chain have made significant strides in reducing greenhouse gas emissions. Many participants have pledged near zero emissions in the coming decades. The U.S. natural gas industry is keenly aware of the importance of reducing greenhouse gas emissions and can play a significant role in winning the climate change battle. Thank you.
Thank you, Ms. Outram. And finally, we have Melissa Hoffer, Principal Deputy General Counsel at the Environmental Protection Agency. Ms. Hoffer.
Good morning. Thank you to the FERC staff, and thank you, Catherine, for organizing today's technical conference on this critically important topic. I really appreciate the opportunity to be here on behalf of EPA today. So I'd like to start by placing our discussion a little bit in a broader context of what we're aiming to achieve. The IPCC's recent AR6 report estimated that to have a 67% chance of limiting warming to 1.5 degrees centigrade, and that's about 2.7 degrees Fahrenheit, the world's remaining carbon budget is 400 gigatons of CO2. So that means we can't exceed that budget if we want to limit warming to safer levels. Global emissions are about 40 gigatons of CO2 annually. So the world has only about 9 years until the budget for 1.5 degrees is reached at current rates of production. That means if we don't reduce emissions rapidly, the IPCC projects the world will likely pass that target in the 2030s. Exceeding that target, even briefly, will have negative consequences for the world. The effects of warming are already being experienced. They're dangerous, they're costly, and they're disruptive. We need only look to see what's unfolding in British Columbia this week. Current rates of fossil fuel production and consumption must be reduced significantly within the next decade. That means we have to decarbonize the power sector. The Biden administration has set a goal to reach 100% carbon-free pollution, electricity by 2035, and that's just 13 years from now. So that's our collective goal, and I think, sort of that's what's informing this effort and this opportunity for us to come together and talk about how we approach these problems. On the question of mitigation, FERC has legal authority under the Natural Gas Act to both consider greenhouse gas emissions as part of its public interest review and to require mitigation of greenhouse gas emissions. And of course, it must consider greenhouse gas emissions as part of its NEPA environmental review. Supreme Court has recognized air quality and environment are relevant considerations for FERC's public interest review under Section 7. FERC's 1999 policy statement provides that the goal of the pipeline certification process includes avoiding unnecessary environmental and community impacts, and its illustrative list of benefits includes advancing Clean Air Act objectives. DOE has recognized that environmental factors fall within the scope of its public interest review for natural gas exports. The State Department has also similarly broad discretion to consider public interest factors when issuing presidential permits. So as Commissioner Glick noted in his introductory remarks, the Court of Appeals for the District of Columbia has been crystal clear that FERC can consider environmental impacts as part of its public interest review, and it may condition certificates to mitigate foreseeable harm. Now, for mitigation, FERC should take into account all project GHG emissions, direct and indirect, including upstream and downstream. Those emissions are foreseeable. They must be considered under NEPA, and we can review that in more detail as our discussion unfolds this morning. But FERC could evaluate mitigation for direct and indirect emissions in a similar manner. It may opt to choose from the same menu of mitigation options for each category of emissions. Those options might include things like requiring the use of equipment that minimizes emissions, electrifying motors, for example, electric turbines for compressors, requiring methane emission reduction measures additional to any required by law. It could use high quality or verified offsets where emissions have already been reduced as much as practicable, and it could consider limiting certificate terms. Certificate term limitations could ensure the public interest in avoiding more dangerous levels of warming is not undermined by locking in long-term greenhouse gas emissions. And of course, the Commission can deny certificates where the harm can't be effectively mitigated. I want to briefly mention, as EPA noted in its May response to FERC's NOI, the Commission could apply the social cost of greenhouse gas as part of its public interest economic test, as part of its environmental review, and that analysis would be extremely useful to help the Commission appropriately value the required mitigation. So, for example, using the social cost of greenhouse gas, the Commission could require mitigation options to offset total present value of the project's climate-related damages. Thanks.
Thank you, Ms. Hawker, and thank you to all the panelists for the robust intro discussion. We're going to open it up for follow-up questions, and I believe first we'd like to hear from Chairman Glick.
Thank you very much, Katie. And I want to start by recognizing that this is a technical conference, but there are some legal issues that I think we need to address. And so I just had a couple of questions. And if you don't mind, Chairman Kelleher, I've known Chairman Kelleher for a long time, and I've always had great respect for his intellect. I have to say I'm a little astounded at the position he takes, so I just wanted to ask you a couple of questions, if you don't mind. So I read Sable Trail again last night for like the 100th time, and I know you're familiar with Sable Traffic. You work for a company that was a party to Sable Trail NextEra. And just want to ask you that the court said FERC has the authority to deny a certificate if a pipeline certificate on the grounds that the pipeline is too harmful to the environment. Do you agree with that?
I agree. That's what the court said. Yes, if that's your question.
So that's the precedent that we're operating under.
Well, the same court also said that the Commission cannot use its conditioning authority to regulate matters that are falling within the exclusive jurisdiction of the states under the Gas Act. And the same court said that the Commission cannot use its conditioning authority to insinuate itself, again, the court's term, not mine, into matters that are reserved to other federal agencies such as EPA and the Clean Air Act. So I think it's balanced. I agree with your first, but I think there's three things that have to be balanced there. And the question is, what's the product of that principle you pointed and the two limitations that I noted that the same court established? There's some residue there.
Well, then let's look at what the court said about mitigation. The court actually specifically talked about greenhouse gases and said that the Commission has the authority to mitigate reasonably foreseeable downstream, in this case they were talking about downstream greenhouse gas emissions. The court actually, the EPA regulates emissions. You're right, EPA also regulates NOx emissions and SOx emissions, and we certainly have, there are mitigating conditions in our certificates on those issues as well. But the court specifically was talking about greenhouse gas emissions, and it said that we have the authority, FERC has the authority to mitigate reasonably foreseeable greenhouse gas emissions.
I agree. They also said you can't use your conditioning authority to regulate matters reserved to the states, which is upstream and downstream, and you cannot use your conditioning authority to regulate matters reserved to other federal agencies. And also, part of the confusion is mitigation. We're using mitigation in two different senses, and the courts use it, I think, in one sense. Mitigation can mean reduce impact, right? When you change the route of a pipeline, you're mitigating the impact on old trees and wetlands. You're reducing the impact. But today the conference is using mitigation in a different sense of offsetting an impact. Not reducing the impact, but offsetting. And I think the Sable Trail decision you read could be read as saying FERC can condition to reduce the greenhouse gas emissions. I don't think they're saying you're off to the races on offsetting everything.
Well, so you're suggesting we could mitigate greenhouse gas emissions as long as we don't offset all the emissions.
I'm saying that I think the court there wasn't using mitigation in the sense of offset. They were using it in the sense that they've usually looked at it in a FERC case as reducing the impact, not offsetting the impact, reducing it. But I do think, right. I agree with what you quoted, but I think there's two limitations that also have to be recognized and not ignored.
Well, let me ask you, and I don't want to hog the time up, but we have a lot of questions, actually a lot more important technical questions too, but just quickly on this, going back to what I quoted earlier, when the court said we could deny a pipeline certificate on the grounds that it would be too harmful to the environment. Let's just say a majority of commissioners said that a particular project has a significant amount of greenhouse gas emissions and it would have an adverse effect on climate change. If we can't mitigate that impact, then according to the court, we would have to deny the pipeline certificate. Is that correct?
The court has said the commission can reject a certificate if the environmental effects are, I don't know if it's undue. I think it was undue. And I don't disagree with that at all. I think one area you and I agree with is the commission has not done balancing well in the past. And I think balancing should weigh what are the environmental impacts. And to me, that can include the direct emissions, GHG emissions from projects, and then what are the benefits of the project. I don't think the commission has done balancing well, but I think that's the right place to consider loss of old trees, wetlands, and direct greenhouse gas emissions.
So, and just to finish up again, I don't want to hug, I'm taking up too much time, but I think we agree in one area, which is, I think you're right, that to the extent that an environmental impact is significant and you believe the project is needed, and environmental impact is significant, that you have to figure out a way to get that impact below a significant level, otherwise the commission has at least the capability, the legal authority to reject the pipeline. Now, we could do that, or we could try to figure out a way to mitigating, which is, I think, what we're mitigating, what we're talking about today. But I want to make it clear that the court was talking about downstream emissions, not just direct emissions. With regard to, it was reasonably foreseeable downstream emissions, the court said what we had the authority to mitigate on. And
I agree it's confusing because the same court said the commission cannot use its conditioning authority to address areas reserved for the states, which would be downstream.
It's not confusing to me, but I respect your intellect, and we obviously disagree. But I'll yield it back to you, Katie. Thank you.
Thanks.
Thank you, Chairman Glick. I believe Ms. Stannis and then Ms. Foster would like to follow. Stannis.
Thanks, Katie. I just wanted to note that I think that the conversation is really conflating two really important ideas, and I just wanted to take a second to disaggregate those because we're conflating mitigation with regulation. And once you conflate those two ideas, then the legal waters get really muddy. So the commission, I don't think Chairman would disagree, cannot regulate downstream emissions. But that's an independent question from whether or not the commission can attempt to mitigate public harm that would be caused by its authorization of a project. So by conflating it and saying the commission can't regulate upstream and downstream emissions, no, it clearly can't, which has to be part of its analysis. And that's why the commission has to really carefully examine its role in certification and whether or not the aggregate greenhouse gas emissions, unmitigated, the cost-benefit analysis, once it contextualizes it, outweigh or are outweighed by the financial and public benefits of the project. But the attempt to try to mitigate the harm from its decisions and to consider the harm from its decisions are well within the Commission's NGA ambit, and that is entirely distinct from whether or not it can regulate upstream or downstream emissions.
Thank you, Ms. Stannis. Ms. Hoffer, do you have a follow-up?
Thanks. Yes, and my comments are along the same lines. I just wanted to go back and talk a little bit about some of the earlier United States Supreme Court cases on this point. The Supreme Court, as far back as 1961, recognized the potential for improved air quality as an important consideration under the public convenience and necessity standard applied by FERC's predecessor, the FTC. And in fact, the court in that case, this is FTC versus Transcontinental Pipeline Court, found that that kind of consideration of improved air quality was entitled to be given great weight. The court also recognized in a later case, NAACP versus Federal Power Commission, that the Act had several subsidiary purposes, including relating to conservation and environment. So these older authorities help us understand that for a very long time, the courts have recognized that built into that public interest review is not just the authority, but the obligation to consider these other factors. And what that means as well, and I'm just, I'm thinking about the discussion we just had on Sable. I mean, the court really could not have been much clearer in that case. As we have noted, it says greenhouse gas emissions are an indirect effect of authorizing this project. So the Commission's very step in authorizing the project is an indirect effect, which FERC could reasonably foresee and which the agency has legal authority to mitigate. 15 U.S.C. Section 17Fe. So, that means that when we do a public interest review and we go through that balancing step and we identify harms that haven't already been mitigated by proposed actions of the project proponents, the Commission does have the authority to mitigate those harms because envisioned all along in the framework that Congress put in place through the Natural Gas Act is a desire to take into account and balance harms and benefits. So how could the Commission possibly do that if it didn't also have the concomitant authority to mitigate those harms? And it is distinct and separate from regulation. Thanks.
Thank you, Ms. Hoffer. We also have a couple of follow-ups. We'd like to hear from Chairman Kelleher, followed by Mr. Hallam, and then Dr. Tierney. Chairman Kelleher?
I just wanted to quickly respond to the comment that mitigation of upstream and downstream emissions could not possibly be considered regulation. I think it would be considered indirect regulation. I think it's exactly the kind of thing the Supreme Court found in the Utility Air Regulatory Group as an overreach, where here the Commission would be taking a generic, inoffensive 1947 provision, the conditioning authority, and using it to assert some level of control over economic activity downstream of a project. And I think, I just don't think that's going to withstand scrutiny. So the reason I'm here today is basically say there's another approach that can produce greater savings that will be legally durable, unlike the policy that's being considered.
Thank you, Chairman Kelleher. Mr. Hallam?
Well, maybe I can redirect the conversation a little bit away from the legal aspects and more to the technical or practical aspects of the pipeline operations. And what I would first say is I think, it's been demonstrated multiple times now that as pipelines are denied, that we see several factors that occur. One, there's a disruption in supply. There are increased costs to end users, and that local regionalized air emissions are immediately and acutely impacted. And I think we can look at examples that illustrate that point in the Northeast and in New England. So that's my first point from just a practical aspect of what natural gas infrastructure does provide for us from an immediate standpoint. Secondly, is that what we're seeing across the industry are that pipeline projects are being designed for today and the future. At Williams, we are designing our pipeline infrastructure projects to have capacity to transport renewable natural gas. to transport varying percentages of hydrogen blended into the natural gas. And we believe that, we're an industry of miracles and major changes that have taken place over the course of our time. And I believe that we're going to continue to see energy continue to evolve and advance and move us into a clean energy economy that also delivers low cost for our end users. And so I believe that part of this conversation has to include what pipeline infrastructure industry is doing today to enable the future clean energy economy, and that needs to be factored into our thought processes and discussions. Lastly, I would say that we see demand continuing to evolve. On Transco, we used to be a pipeline that moved gas from the Gulf Coast up to the Northeast. Today, we have reversed our pipeline, and we see it across the entire, interstate industry, where they have efficiently continued to advance their infrastructure to meet the demands at the lowest cost possible. And so I believe as, demand evolves, populations move and shift, fuels change from a high carbon to low carbon, that natural gas infrastructure has to evolve with it. And it's not just from a geography standpoint, but also from a materials of construction, tolerance, and ability to enable a clean energy future. Thank you.
Thank you, Mr. Hallam. Next, we have Dr. Sue Tierney, followed by Patricia Altram. Dr. Tierney?
It's with some hesitance that I enter into comments on this back and forth on legal issues because, of course, I'm not an attorney. But I thought I would do two things. First of all, my comments have been hijacked a tiny bit by Mr. Hallam's statement that when the Commission denies a pipeline permit, various things happen. I can count on one hand across the more than hundreds and hundreds and hundreds of applications where the Commission has denied a permit. So that I just want to remind everyone of that context. But more importantly, I'm going to go back to Commissioner Danley's reference to the NAACP opinion, in which the Supreme Court said that the purpose of the Natural Gas Act is to enable the orderly development of plentiful supplies of natural gas at reasonable prices. So I'm going to focus on the word orderly rather than the words plentiful supplies, because the orderly development is the gateway through which the comment is made by the court. So I question whether it would be orderly in the public interest review to not take into account the fact that there could be stranded costs associated with new pipelines that are authorized by the Commission in the context of, say, deliveries into a state where that state has a statutory requirement to reduce its greenhouse gas emissions over time. So it would not be orderly to authorize, but I mean, you can imagine cases in which it would not be orderly development to approve such a project. Mr. Hallam suggests that there could be instances in which a pipeline approved today were being put in place for, say, green hydrogen deliveries. So would that mean that in order to find that that were an orderly development, the project should be conditioned on operations under that circumstance? Because otherwise, the project, again, may find itself having lower and lower and lower utilization factors in the context of a marketplace in which the state is clamping down on emissions. So I just wanted to return us to that purpose of what we're talking about here, and then let all of you legal beagles argue. Thank you.
Thank you so much, Dr. Tierney. Ms. Outram? Ms. Outram, I believe you're muted.
Sorry, thank you.
Thank you.
move this back to kind of a global viewpoint, if you will. First, a technical piece. The staff of the FERC have said that they don't have the tools to analyze this emission, the greenhouse gas emissions. Now, there's some things out there, but those models are really designed for global analysis. They're not designed for analysis of unique, small projects, okay? So we have some technical issues as far as being able to even analyze where we're going with all of this. But the second thing is we can all agree that climate change is a global issue. It doesn't have to do with this project or that project, it's a global issue. And if projects are going to be able to provide a particular area with a fuel that is going to cut their emissions in half, that means that that project is beneficial on a global basis. And I think that piece needs to be identified and needs to be brought into consideration. All of the value chain has looked at greenhouse gas emissions, and they are working very hard to reduce greenhouse gas emissions in every way possible. And as Mr. Hallam said, those pipelines that are being developed will be able to produce or will be able to transport green energies, whether it's fuels that are being capturing carbon and recycling carbon in order to be able to produce fuels, or whether it's hydrogen being introduced into the gas stream. So pipeline companies, LNG companies don't build their facilities on a whim. They look at a 40-year window, and they are only built if the market sees that during that 40-year window, those assets are going to be able to be utilized. So you don't have to worry about stranded assets. The Northeast has really high gas prices because the pipeline companies can't put pipe in the ground to bring additional supplies in during the very peak seasons. That's the reason why the high prices are in the Northeast. So there are market issues that will adjust this whole thing, and there are market issues that are driving the companies to do more on greenhouse gases. And so in that realm, I'm not sure that FERC needs to weigh in on that because the market will take care of the problem.
Thank you, Ms. Outram. Ms. Hoffer, would you like to follow up? And then we'll move on to the commissioners.
Yeah, listening to our conversation, I'm wondering if we're not making somewhat of a category error here in our definition of the problem of climate change. It's possible to look at it through many different lenses, and of course, it does constitute a problem from a number of different perspectives. But climate change is really expensive. It's really expensive. It is an economic issue. So for purposes of the Commission's public interest review, when it's deciding whether to authorize construction of major new gas facilities, it's balancing public benefit against potential adverse consequences. And this is, it's essentially an economic test. You're looking at whether the applicant can support the project without relying on subsidies. You're looking at whether the applicant has made efforts to minimize adverse effects on landowners. And you're looking at residual adverse effects remaining after that. And only when benefits outweigh the harms, effects on specifically economic interests, the Commission, proceeds to consider an environmental analysis. So, in a way, this methodology, it fails to account for the significant economic impacts of climate change. It sort of relegates the environmental assessment to a subsidiary consideration. There was a study that was done not too long ago of all 125 major pipeline approvals that were issued by FERC from 2014 to 2018. And it reviewed FERC's approval decisions and the relevant supporting documents, including any EAs or EISs. It found that FERC often bases its approval of pipeline projects primarily, if not exclusively, on an assessment of economic impacts. So the question for the Commission's consideration then is how might it be possible to incorporate consideration of pipeline GHG adverse impacts directly into the public interest review. And, you know, we have that tool. We have that tool in the form of the social cost of greenhouse gases for a proposed project. You can then monetize those harms and include that cost, that adverse economic impact, just as a part of your normal Natural Gas Act economic balancing. Social cost of greenhouse gas allows us to understand what the cost, expressed in dollars per ton, of current and future damages caused by GHGs. So let's just have it be an even playing field. Clearly, there are some benefits of gas pipeline projects. We can often monetize what those are. So let's also monetize what the costs are of those projects in terms of social benefit or social harm. And then the Commission has the information that it needs to really make an informed decision, because right now the Commission doesn't have that. And you're trying to make a decision on particular projects without having the full benefit of the very information that's going to help you do that. So I'll leave my remarks there, but a very important tool so that the Commission has the information that it needs to make the best decisions, and you've got it for both the costs and the benefits, thinking about ways to monetize the costs of climate change. Thanks.
Thank you very much, Ms. Hoffer. Chairman Danley, or Commissioner Danley, do you have any follow-up questions?
Not right this moment, thank you.
Thank you. Commissioner Clements, do you have any follow-up questions?
Thanks, Katie. I would like to hear maybe from Sue or others on the tools, what we actually use. Melissa, you just mentioned this, but can you say more about whether or not the social cost of carbon is a good tool to use in the context of an individual proceeding that falls under this framework, or are there other things that you are thinking about in terms of how we monetize the GHG emissions?
Thank you very much for the question, Commissioner. Yes, I think that we have tools to estimate the reasonably expected impacts of a project, of the upstream emissions, and of the downstream emissions. Routinely, myriad parties in the economy and in government decision-making rely on forecasts and potentially robust scenario analysis to look at how gas is produced, how gas is used, and of course one can very technically, capably look at the impacts associated with delivery of gas. There are data sets that are available from government agencies like the National Energy Technology Laboratory, like the Environmental Protection Agency, like the Energy Information Administration, all of which provide different metrics associated with the greenhouse gas emissions associated with one set of activities or another along the supply chain. So that would, using such data and forecast analysis that people use in decision making all the time for energy decisions, energy facility decisions in particular, then one can identify the number of reasonably expected greenhouse gas emissions along the supply chain. And then one would apply the social cost of carbon to those emissions in order to monetize them along the lines that Melissa Hoffer just described. Melissa. And the social cost of carbon is a highly credible, peer-reviewed analysis that looks at the costs of impacts of greenhouse gas emissions across the economy. It is one can kick the tires and see transparently what are the economic studies that are associated with the number that has been determined as the social cost of carbon in any year associated with the next greenhouse gas emitted. And so I do think that we have both a methodology for counting reasonably expected emission levels and the monetary value of those. And those are important tools for enabling the Commission to do this balancing test between the economic impacts of and benefits associated with adding a new increment of capacity, and compare those to the economic impacts associated with the myriad greenhouse gas climate-related emissions. Thank you.
Thank you, Dr. Tierney. Commissioner Christie, do you have any follow-up questions?
Yes, just briefly, I found a back and forth between Chairman Glick and former Chairman Kelleher to be very interesting, very educational. It effectively was a debate, and I like that, and I found it to be very, very educational. I think it pointed out that there's really two issues here, legal issues. One is mitigation and how far the Commission's authority goes. The other issue is rejection, outright rejection of the CPCN. And let me talk about rejection for a second, because that was what the debate was about between current chairman and former chairman. We need to remember, and I'm going to go back to my opening statement, what a CPCN is. It is a finding by FERC or any other regulatory agency that an infrastructure facility is needed to serve the public. Remember, CPCN stands for Certificate of Public Need and Convenience. It is needed to serve the public. So to claim that once FERC has made the finding that a facility is needed to serve the public, FERC can then turn around and reject it based on something, let's say, like a social cost of carbon metric. It raises a very important question. I mean, I think it raises a huge legal question, and it's a huge question of public policy. So I think the back and forth between Chairman Glick and Chairman Kelleher was very educational on this central question about whether, after a finding of public need, that a facility is needed to serve the public, that FERC can then turn around and reject it. That's a major legal question. It's a major public policy question. And I like to ask that we have if not an oral argument, I don't know if you can have an oral argument here at FERC. We used to have oral arguments at the Virginia Commission frequently on issues of this importance. But maybe we can have a technical conference on this very legal question, which I think is a huge question. And it's different from simply the question of how much mitigation can we do. So I really enjoyed that back and forth between the two chairs, or former chair. I hope we can have another technical conference devoted to airing out these very important legal issues so we can thoroughly air these out before this commission actually acts to try to reject a project when we found that it is needed to serve the public. Thank you.
Thank you, Commissioner Christie. Mr. Hallam, did you have a follow-up?
I just wanted to remark on the social cost of carbon in that we see it as an imprecise, speculative, and theoretical tool that shouldn't be used to justify a project. I mean, even the interagency working group that created the social cost of carbon has repeatedly acknowledged limitations of SEC, stating that any effort to quantify and monetize the harms associated with climate change will raise serious questions of science, economics, and ethics. We are, interested in this continued discussion around the balancing test and what criteria should be used. We have strong concerns around the social cost of carbon as that metric that would be used. Thank you.
Thank you very much, Mr. Hallam. Dr. Tierney, and then Winnie Naismith, would you like to follow up?
Yes, please, on 2 points. First, to Commissioner Christie's point about the juxtaposition of a public need finding that then might be followed by a rejection due to information that was revealed from using the social cost of carbon. Speaking for myself, I have always assumed that if the Commission were to move to reliance on a methodology that monetized the impacts of greenhouse gas emissions, like the monetization of, construction dollars, that would occur before the determination of whether a project is needed. So, again, you have information about the economic benefits of a project, and you have information about the economic costs, including those costs of climate change. And then if there are net benefits in the Commission's point of view, then it would be approved. And so I see the rejection as potentially occurring as part of that balancing test, not after it. And then secondly, with regard to the social cost of carbon and whether or not it is sound and based on technical analyses, the FERC has so much experience looking at technical questions of what is the cost of capital, what is the discount rate to use in one analysis or another. The Commission looks at all the time on issues in which experts disagree about methods, about results, about data inputs. This is not inherently different than that in my point of view. People in my business look all the time at those different elements of a cost analysis and go behind them to see whether or not one of the elements is, you can kick the tires and see what's happening. Categorically, the social cost of carbon fits into that same framework of technical analysis that has had a huge amount of scrutiny, and it will be updated over time, as one would see for a cost of capital, as one would see for the application of a discount rate for a particular company or another. Thanks very much for letting me make those additional comments.
Katie, you were on mute.
Thank you. Thank you, Dr. Tierney. Next, we're going to move on to Ms. Naismith, followed by Chairman Kelleher, and then we'll move on to the rest of the program.
Thank you so much, and I know we need to move on. In the interest of time, I'll make this really quick. I will defer entirely to Dr. Tierney about the merits of the social cost of carbon and the Commission's experience in dealing with tools that don't have 100% certainty, but as Dr. Tierney pointed out, you can kick the tires, you can look behind, you can see the data that supports the tool, and that consistently across the board with the social cost of carbon, whether you look at EPA's recommendation, the IPCC, experts have embraced that tool as being one that is eminently applicable to the sorts of considerations that FERC is using. Also picking up on something Dr. Tierney mentioned about wanting to have a level playing field. I find it interesting that spokespeople from the industry side are very eager to point out any small flaw or any small uncertainty in a tool like the social cost of carbon, and yet make promises about future use of pipelines that frankly are not supported by evidence. Hydrogen, there's no proof whatsoever that the use of hydrogen could be scaled up or renewable natural gas to meet the kinds of needs that we would need it to meet. And so FERC does need to make sure in all of its considerations that the playing field is in fact even, and that any kinds of tools or promises being made are in fact being made based on solid evidence like the kind that supports the social cost of carbon. With respect to the question of need and project need, I also would welcome an opportunity to delve more deeply into that, but I will say very quickly and simply that the concept of need does need to include climate change. And I would agree with Dr. Tierney that it is not just a question of after the fact employing a social cost of carbon, but in fact considering the realities in the need determination. That, for example, there's a federal requirement now to reduce emissions in this country. There are state laws in place to reduce emissions, and there are state planning processes occurring right now that are aimed at substantially and aggressively decarbonizing the economies of those states. New York is a perfect example where the plan is to get off gas. And that is absolutely something the Commission should be considering in the need determination, not as an afterthought that would then have to somehow outweigh a need determination that's made independent of what is actually in the public convenience and what is actually in service of the end use, the end consumers. Thank you.
Thank you, Ms. Naismith. Chairman Kelleher?
Thanks, Catherine. Just quick response to my friend Sue, and not a nasty response. I agree with you. There's a lot of confusion because part of this discussion is It's looking at how can GHGs and how should GHGs be considered in NEPA analysis, and then what, to some extent, they should be considered in Natural Gas Act decisions, right? And so there's movement between those two. And then if it's going to be considered a natural gas decision, at what point? Is it the point that Commissioner Christie laid out, or is it the point that you suggested? I think it should be a different point. It should be in the balancing itself, right? When you're balancing, that's when you're supposed to make the decision on whether to grant the certificate. You're balancing on the Commission's certificate policy statement. You're balancing the project impacts, which would include environmental impacts, which I think can include GHG emissions from pipeline operation. I'm talking about direct emissions, against the benefits of the project, which should include need. I don't think the Commission's been doing balancing properly under their own certificate policy statement for many years. But I really think that's the right place under the Gas Act, put NEPA to the side, to consider GHG emissions. And then you make a decision. And it could be that those impacts, GHGs plus other impacts, eclipse the benefits. And then you don't issue a certificate. And the other comment is on your definition of orderly. I had time to look up the dictionary definition, and it means a disciplined, methodically arranged process. And I would say I don't think the Commission's process currently is very orderly because it's so untimely. I think the Commission's certificate process for 8 years has been really attenuated, and I don't think it could fairly be characterized as orderly. And that's not a criticism of any current member of the Commission, because it's been something 8-10 years long phenomenon. So just a little quibble on that. Thank you.
Thank you, Chairman Kelleher, and thank you also to the rest of the panelists. Like Commissioner Christie, I really enjoy a good oral argument, so I'm loath to move on to some of the specific set-piece questions that we have, but I do want to make sure that we get time to seek the panelists' input on a few of those questions. And I'm going to start with one, and please bear with me as I read it so that I don't miss any of the key elements. And that is, when determining the amount of reasonably foreseeable GHG emissions associated with the proposed project, how should the Commission consider each of the following factors, or others if the panelists have those in mind? Project utilization projections, state natural gas usage projections from a PUC or other relevant entity, individual emissions data for consumers, and then last but by no means least, the netting effects that come with using natural gas to change or displace other sources of emissions. Just throw it open to the whole panel, whomever wants to jump into that first. I think everyone's familiar with the raise hand functions by now. There's some evidence of that, so over to you, panelists. We'll start with Dr. Kearney, since she's first out of the gate.
Thank you. It was appropriate that I not comment on legal issues in my written comments, and I focused very much on this one question that you have just raised, Mr. Christensen. And all of those factors that you have identified and more should be part of an analysis that looks at whether a project is needed and what I'm going to focus first on the environmental impact. Those factors affect the projection of emissions from a project when one is looking at the downstream effect of combusting gas for different types of end uses. In my written comments, what I suggested was the Commission could establish a default methodology and perhaps default indicators in a market where there are uncertainties associated with how a gas project and its incremental delivered gas would be used. And what that might be for a different region, for one region or another, that might be an expectation that the gas would go into a soup that fueled over time both residential, commercial end uses in buildings, potentially maybe natural gas for vehicles, potentially power generation. And there are estimates associated with the greenhouse gas effects of using gas for those different purposes. And I've already mentioned a couple of sources of information. There could be a requirement that every applicant use a particular set of data, and if that applicant were to think that the project had different impacts, the applicant could also provide that. For example, if the shipper for a project were predominantly going to be a member of the power sector, one could look at power generation emissions associated with combusting gas. Now, projection should take into account displacement of gas, displacement of perhaps propane or coal in a market, and that could reduce greenhouse gas emissions associated with the entry of gas into a region. And the default methodology could take that into account. I think Ms. Outram said that if a project were to offset the use of coal in international markets, then that should be a reduction of greenhouse gas emissions. I agree in terms of this analysis, and again, standing on different credible sources of information. If a state is expecting to reduce its greenhouse gas emissions, as we have just heard could occur if the gas deliveries were to be consumed in New York, one should expect that the reasonable estimate of the use of gas would go down over time. And so all of these sources of information are relevant, including the utilization factor. Now, I suggested that a default be the utilization factor at full utilization. Mr. Hallam suggested that load factors vary according to the season of the year. Then perhaps one of the things that the Commission could do, if it found that a project were needed and there were downstream and the life cycle emissions of greenhouse gases were taken into account as part of that balancing test, then one could condition the operations one could condition the, perhaps it is operations of the project such that if the load factor were to go above that assumed level, then there could be offsets associated with that as part of the condition for that project that's needed. I don't want to continue to go on because I know everybody wants to talk about this, but I'm happy to return to any of these issues. Thank you.
Thank you, Dr. Tierney. Next up, we get Mr. Hallam.
Okay, first, I just wanted to double back real quick and say that, I agree with Monine's point that our energy transition is about different fuel mix, future mix. And, I do think that there's a more robust discussion that we need to have around how we think about gas projects and maybe the metrics that we use. My concern was more around the social cost of carbon being used exclusively as it is today as a key metric. So I think that's where this discussion could continue beyond today, is around how we think about a metric if we were to use one. As it relates to the question you mentioned, there are a lot of things that I agreed with in Sue's response. What I'm challenged with as an operator of a pipeline and developer of projects is that, not all projects are the same. The natural gas network is complex. It's a spider web. And, through the market forces of supply and demand, there are disconnects or dislocation of pricing that promotes natural gas projects to get the lowest cost energy to the end user. And so for that reason, there are projects that are advantaged in being able to provide the information that was outlined. But I think there are also projects that are disadvantaged in being able to provide with authenticity the degree of information that I think that Sue was mentioning. So if there's an evaluation of reasonable foreseeable greenhouse gas emissions associated with a pipeline project, then the such evaluation should take into consideration reasonably identified end uses and projected load factors usage of the project capacity. Also, the extent of which greenhouse gas emissions from downstream end use may be an offset or mitigated by displacing other sources of fuel such as coal, oil, and propane. And then lastly, other offsets or mitigations of projected downstream greenhouse gas emissions through regulatory requirements promulgated by an environmental regulatory agency. And then lastly, as an operator of a pipeline, what I see is the continual evolution of how our pipeline systems operate. Not only renewable natural gas that's traveling through our network today, and that we are beginning to blend hydrogen into our natural gas networks here in the States and overseas, but also the use of carbon capture, use and storage, and keeping ourselves and our regulatory approach open to how these future uses are going to continue to decarbonize our energy infrastructure system, and not curtailing our ability to transport these resources based solely on the decision of natural gas today, when in the future it could be much more dynamic. And I want to make sure that we're keeping, this test that we would be applying open to the continued innovation that, we have demonstrated here in the United States and in the energy infrastructure space. I think that's important to keep in mind as we have these discussions. Thank you.
Thank you, Mr. Hellman. Chairman Keller?
Thank you. I'm going to take the question as asking about GHG emissions that are not just reasonably foreseeable, but also legally caused by the project. So just a slight amendment and a question, if you'll allow me. And I do think the way the Commission analyzes GHG emissions, particularly downstream emissions, in the context of NEPA analysis is sorely lacking and needs to be revised. And I think some of the current approach, two particular aspects of the current approach, have the effect of grossly exaggerating the downstream GHG emissions identified in NEPA analysis. First one is use of the full pipe assumption. The assumption that projects operating at full capacity, 24 hours a day, every day of the year. That approach has the singular virtue of simplicity at the cost of anything approaching accuracy. There, to my knowledge, there's no pipeline that operates in that manner. And I can't understand why the Commission persists in assuming full capacity, full utilization. I think there's an obvious alternative approach, and that's to take either a national or regional average, or at least establish that as a rebuttal presumption and let parties say, no, I think this pipe's going to be used much less than the national or regional average, or much more. But it seems applying a national or regional average with respect to utilization is a truer way and a fairer way to try to estimate downstream GHG emissions in the context of NEPA analysis. The other one is the Commission really, I think, does a poor job I think the Commission tends to disregard netting. The best example I can think of is the Sable Trail project, which we've talked about a number of times so far today, where that's an unusual project in the sense that the use of the project was foreseeable. There were power plants that would consume the natural gas from the project, but otherwise didn't have access to natural gas. So there you had much more foreseeability and arguably causation than you would in almost any other project. But those new gas projects were allowing the retirement of coal projects. That retirement was as foreseeable and as directly caused by the project as the gas projects themselves. Nonetheless, the Commission completely ignored the savings from the retirement of those coal plants. Now, if the Commission had factored that in, again, I think that's as foreseeable and the same causal relationship as the gas plants. That project would have been a net negative, that would have had net negative emissions. Notwithstanding, the Commission ignored netting and it attributed it as having fairly significant, not significant in the context we're saying today, but some level of downstream GHG emissions. I also think it can be nearly impossible to identify the downstream uses, particularly when uses, particularly a pipeline-driven project. Right, a pipeline-driven project is a demand-driven project. You will have utilities, typically gas or electric utilities, that don't necessarily have specific use for it, but their system needs more gas. But a producer-driven pipeline, they're looking for the higher basis pricing in the destination market. I think it can be nearly impossible to define how that gas will be used in the destination market. So anyway, just short comment. I think the current approach really exaggerates the downstream gas emissions and should be revisited.
Thank you, Chairman Kelleher. And before we move on to Ms. Outram, I just wanted to ask one sort of quick follow-up question, and that is, I think I heard both Chairman Kelleher and Dr. Tierney talking about sort of default rules, for lack of a better term, whether it's pipeline utilization rate, or I can't remember, Dr. Tierney, exactly what you had, but as a way of forcing additional and putting additional information in the record. Do you want to speak a little bit more just on the general approach of using default rules like that, briefly before we move on to the other panelists?
Mr. Chairman, can I go forth? Do you mind if I, that was to you, Mr. Kelleher, when I said, Mr. Chairman. Let me say, one could use, in the instance of the case where Joe mentioned that it's harder to do greenhouse gas emissions in a destination market. One could look at the overall portfolio of use of gas in a destination regional market and use that as a default amount associated with the incremental impacts of adding one more BTU of gas into that market. So even if one doesn't know the exact use, it would be as wrong to assume you can't figure it out, so there's zero, as it would be to assume in all cases it was the highest emitting factor. So there are data sources that provide insights that could help create these defaults for standardized emissions in a market, standardized emissions from a new combined cycle gas-fired power plant, and so forth. And then, as I suggest, the Commission could accept tailored approaches where the applicant or an intervener feels that a tailored approach was appropriate for actually pinning down the greenhouse gas emissions for a particular project.
Thank you, Dr. Tierney. Chairman Kelleher, do you want to add anything to that before we move on to the other panelists?
No, thank you, though.
Thank you. Ms. Outram.
I would like to just point out that and there's lawyers on the call that can do this much better than I can, but there is a box that the Commission is supposed to play in, and I think that legal box the Commission tends to want to push those sides out and climb out of the box and go do other things. I think it's really important. There's a reason why the regulations have limitations on them, and I think it's important that we stay within those limitations when we start looking at these things. Upstream and downstream, especially in the LNG industry, upstream is very hard to nail down, and downstream, where is the destination of that LNG going is generally very difficult to identify at the time when you have an application. But in most instances, the downstream means that you're going to be replacing something like coal. So if we're going to crawl out of the box and start looking at these other things that are outside of the legal and regulatory requirements that have been placed on FERC, then I think it's just very important that if you have a reduction in emissions, that also be identified and that be considered in the application.
Thank you, Ms. Outram. Ms. Danis?
Thank you. I wanted to add in just a quick note that all of the criteria and data that Dr. Tierney was recommending that the Commission look at, all of those same data are relevant to ascertaining demand and are relevant to identifying alternatives. And so in the past, there's been a real disconnect between the Commission's assessment of greenhouse gas emissions and pipeline utilization. And so what's happened is, for emissions purposes, industry has argued, well, it should be narrowed because this is actually only going to be used a couple days a year during peak. But in terms of demand, it's argued that alternatives must be able to carry the full capacity 24/7 from point A to point B. And those can't kind of both be reconciled. And so to the extent that the Commission has been operating within a box, it's really because the Commission has been dealing with greenhouse gas emissions for some reason and climate impacts differently from all of the other inquiries. And the Commission's current bid to really predicate these inquiries on data are going to benefit all the other aspects of the Commission's inquiry, in terms of whether the project there is really demand for it, in terms of what the alternatives to the project, what a no-action alternative really looks like, and those other areas in which the Commission has some additional work to do. And so in terms of, what the other panelists have suggested, absolutely, if there are data showing displacement, then those should be considered. But in the dockets that I've reviewed, it simply says the project will yield cleaner air because it will replace coal, without any record evidence going to that factor. So absolutely, these are all questions that are capable of being answered with data and analysis, and none of it is more complicated than what the Commission does in every other aspect of its work. It's not more complicated than the already complicated inquiries that the Commission undertakes. And so the deeper the Commission dives into having benchmarks and presumptions, it's going to benefit the Commission's overall inquiry into need.
Thank you, Ms. Dennis. Ms. Naismith.
Ms. Dennis made many of the points I was intending to make, that one way or the other, these determinations really need to be data-driven. And as Ms. Dennis has already said, too often we see promises of, particularly with respect to netting, that are not supported by any kind of record evidence. Coal-fired power plants are retiring because they're old and they're dirty and they're uneconomic. They're not necessarily being retired because of that same reasonable causal connection between the project in front of FERC and that retirement that is being demanded in order to count downstream and upstream emissions. We have to have an equal playing field, that if we are requiring a reasonable foreseeability of emissions in order to count those emissions, in order to discount emissions, there also needs to be a reasonably foreseeable connection between the project FERC is considering and reductions in emissions. And too often we have seen, again, these very broad, unsupported statements being said in applications and then repeated by the Commission about offsets, be that domestically or internationally. The LNG issue, the idea that we don't know where the LNG is going, we often do, because as a predicate to the entire process, the Department of Energy needs to know whether or not the gas is going to a free trade country or a not free trade country. So the lack of information cannot be, or the claim that there is a lack of information cannot also be, as was said earlier, a reason to assume that the number is zero, or to assume that on the netting side that the number is 100% net, and therefore zero emissions. And I think in addition to that, contrary to Chairman Kelleher's view, we have seen a real failure to adequately calculate downstream emissions, in no small part because what isn't considered is also the fact that although there are going to be improvements made to leakage is not currently factored into that calculation. And as we know, methane is a far more potent greenhouse gas than carbon dioxide. And so again, in order to get a genuinely accurate picture of what effects these projects will actually have, that too needs to be considered. Whether the gas is being transported to a electric generating unit, or even worse in a lot of cases, into a gas utility system in terms of leakage, those things need to be considered in addition to factors that an applicant may bring to bear that, again, if they're supported by data, supported by evidence, absolutely should be considered, such as a lack of full utilization. But too often we've seen a real uneven requirement in terms of proof to support a lot of the contentions of especially offsets, netting, and lack of full utilization. Thank you.
Thanks, Ms. Naismith. So I see we still have a handful of hands up, as it were, on this question, but we only have 15 minutes left on the panel, so I'm going to move on to the next question, and if any panelists want to sort of speak in whatever points they have in mind to this one and answering that question, that's totally fine and fair by me. This question is sort of a broad picture about mitigation levels, and I'm curious what panelists think about whether the Commission should determine mitigation on a project-by-project basis. So I should say should determine mitigation level on a project-by-project basis, or have some standard goal, be that 0, less than significant, or some third option in terms of what is the appropriate level to which to mitigate greenhouse gas emissions. And I see Chairman Teller is first.
I'll be brief, respecting your time. So based on my comments earlier, I don't think any mitigation level is appropriate. But I'm curious about the process that would be used. I'm assuming there would be some kind of estimate on what the annual, if you were to do this, there would be some kind of estimate on what the emissions are associated with the project, downstream, direct, and that there would be an annual true-up, because there would be an understanding that that estimate can't possibly be accurate over the life of the project. So there'd be some kind of annual true-up where if the estimate was high, you bank some credit that you could use in the future, but if the estimate was low, you're somehow buying offsets on a market. I mean, and there'd be some bureaucracy, there'd be some annual audits, and so I'm assuming that's the way the process would work, rather than you would just take what in the past has been a really exaggerated notion of emissions and saying, you owe, before you get your certificate, I demand X offsets. And that if that estimate ends up being wildly exaggerated, you still owe me X. So I'm just curious, is the notion that there'd be some kind of annual true-up, or is it really an upfront estimate that may be high and a mountain of offsets?
Would any of the other panelists like to speak either to that question or to the general prompt? Tierney?
Thank you. Just with regard to Joe's comment, I have assumed that one would do an upfront analysis on the mitigation question, and the Commission would the Commission would establish a standard of the level of mitigation that would be required, such as to get that those emissions down to a insignificant level. So for mitigation, I have not assumed there would be an after-the-fact review and check on an ongoing basis after the Commission makes its decision about a project. But if there were conditions applied in the instance where the project is needed and in the public interest, then I can see situations where the Commission would condition the operations of the project and the need, for example, to add offsets in an ongoing basis. Then that could be based on some of the assumptions that were used in setting the mitigation. But I don't see that as tied to mitigation. I see that as a condition of authorization. I'm just going to take advantage of my having the microphone to say two things. One of them, with regard to LNG and life cycle emissions, the National Energy Technology Laboratory has emissions estimates from source of production basins to use basins internationally. Those could be used as default life cycle emissions associated with an LNG project. And with regard to the question of whether netting should be used, yes, netting should be used where it can be based on evidence, data analysis that people, argue about before the commission. But in the past, the applicants have only included situations where they think that they are going to be improving the criteria pollutant loading in a region or the greenhouse gas emissions. And that, asterisk on that is sometimes they're just claims and sometimes those are based on analyses. But if we're going to do that, then of course we have to look at the instances where there are net environmental adverse impacts. So we can't just do it one way, as the Commission has done in the past, which is just look at instances where there are going to be uses of gas that displace coal or propane. Thank you.
Thank you, Dr. Ms. Outram.
Yes, I'd like to say that, Ms. Nesmith's discussion really points to it validates the point that I've been trying to make, and that is very much that both sides have a lot of assumptions when you start getting outside of the direct impacts from a facility, and both sides, those assumptions can be all one way or they can be all another way, and there's no process by which that we could identify how to move forward with that analysis. The models and the modeling is very specific relative to what assumptions you put into those models. So you've got data in, you got garbage out. So all of this is very assumptive, and everybody knows what happens when you make assumptions. The other thing I'd like to point out relative to mitigation is you got to come from a point of what are you mitigating, and if those numbers, as Commissioner Keller or Chairman Keller has said, if they're way on the upside, then you're saddling the industry, LNG and the pipeline industry, with a lot of additional expense at no good benefit. Okay. And third, I'd like to say again that the market is taking all of this into account. GIGNL yesterday came out with a new methodology, and GIGNL is an international gas union of users. They came out with a monitoring, reporting, and verification process for international buyers. So the market forces are looking at this issue, and the market forces are addressing some of this issue. So the urgency for FERC to jump into this arena, I believe, is much less. And I don't believe mitigation should be part of what FERC looks at all.
Thank you, Ms. Outram. Ms. Hopper.
Thanks. I just wanted to make a couple of remarks thinking about upstream emissions. And, one method that EPA would suggest, you can think about total annual upstream GHG emissions, developing those by summing the estimates of sort of well-known areas of emissions. So on the one hand, we have fugitive emissions, and those are things like leaks and venting and flaring. And on the other are upstream combustion-related emissions, and those are the things that we see through production and gathering and boosting and processing. So, to kind of get a sense of the big picture upstream emissions, you sort of sum those two. And then, EPA would compare the total gas transported by a project to the total gas produced in the United States in a given year, and determine the quantity of gas that's expected to be transported by a project is equivalent to X percent of the total natural gas processing in the U.S. Top-down approach. But then you've got that percentage value, and you can apply that to the total national estimate of emissions that's your fugitive and your combustion related, and you can derive an estimated upstream emissions for a project. So, there's some obvious refinements that are necessary here because that approach it's using only national averages. It's not going to capture regional differences in emissions that would result from things like differences in technology or the way that operator practices or state and local regulations. And obviously, EPA has proposed comprehensive regs that, if finalized, would reduce significantly methane emissions from some of these sources. But it's a start, and it's a way of making use of publicly available data right now that can give us a pretty good sense of what those upstream emissions are, so that they are not, as elusive or speculative, perhaps as the Commission may have perceived in the past. Thanks.
Thanks, Ms. Hopper. Dennis, do you have a couple quick remarks before we hand it over to our commissioners for the balance of the panel?
Yeah, I'll keep it brief. I just wanted to counter a point that had been made about leaving it to the market, and that the entire premise behind the Natural Gas Act is that protecting the public interest and protecting consumers couldn't be left to the market. So the preamble is that the regulation of the transportation of natural gas is in the public interest, not promoting as much infrastructure as possible. And that's the entire reason for the Section 7 careful balancing test and certification process. And so relying exclusively on markets to address the public interest is exactly what Section 7 counsels against.
Thank you, Ms. Dennis. Chairman, commissioners, do you have any remarks you'd like to make before Katie takes us out? Chairman Glick.
Matt, if you don't mind, I do have one other question, and hopefully it'll be relatively quick. But I thought it was an interesting discussion earlier. There seems to be a difference of opinion. Some people think we should do the need analysis first and then do the public interest analysis. And some people think we should do the public interest analysis first and then do the need analysis. And I always thought you do the need analysis first, because if you find the project is needed, that would go into your determination as to whether there was a benefit or not. Obviously, if the project's not needed, there's less of a benefit. But if there's a benefit, and then you weigh that against the adverse impact, bring it back to mitigation. If you think the project's needed, but there's some issues there in terms of environmental impacts, and it doesn't have to be greenhouse gases; it could be anything. That's what mitigation is all about, to get us to a point where the adverse impacts are no longer outweigh the benefits of the project. So I'm curious if you think, if people could comment on whether it's better to do the need analysis first or last.
Chairman Kelleher, do you want to go first?
Sure. I mean, I think the Commission used to make some certain preliminary determinations before they would do the environmental impact, right? And the Commission stopped doing that. And I actually think the Commission should revisit that, because that could have avoided a situation like Spire, as well as some of the LNG projects, where if the project's not needed, then you don't continue. But let's assume there is market support for the project, right? So there's some contracts. So there's market support. Then you do balancing, and that's where I think you could, under the NGA, you could consider greenhouse gas emissions along with other impacts, wetlands, old forest. But in the course of that balancing, it's important to recognize the Commission accepts some impact on wetlands, some impact on old trees, and I think the Commission should accept some impact on GHGs, some GHG emissions, not zero. And then you balance against the benefits. And the Commission makes some decision. That decision could be no, because those net benefits, all three things, accepting impacts in those areas, are too much. But the idea that you would do that balancing without GHGs and then you require complete mitigation, offset of GHGs, to me is kind of perverse, because why would the Commission take an approach that acceptance of some environmental impact on trees and wetlands, that's acceptable. Some impact is acceptable, but no impact is acceptable when it comes to GHGs. I think it just should be part of that. And then that balancing produces a decision on whether to issue a certificate. But I agree, like in the past, it's been, where are your precedent agreements? Precedent agreements show need. Need then is conflated with benefit, I think. And the commission doesn't truly do a proper balancing analysis. Anyway, that's my view.
Thank you, Chairman. Dr. Tierney?
Thank you. I'm going to just jump off of what Joe has just said. I have thought that under a public convenience and a necessity test, the Commission first does, or on the one hand, does an evaluation of demand, and then and sees the benefits of that, and then does an evaluation of cost and adverse impact, and the balancing test is what is relied upon to determine whether there is a net public need, another net benefits based on that balancing test. So Commissioner Chairman Kelleher and I sound like we're in agreement.
This is the only hand. Oh, sorry. Ms. Naismith, late entry.
Yes, sorry, and I'll make this quick. I know we're getting short on time, and this is going to delve into what is an entirely different, or could be the subject of a much, much longer conversation, but I think there's probably not a lot of agreement across this group about how to define need. And I think that is part of the challenge here of what is baked into what does the Commission actually look at in determining need. And you heard me reference earlier the fact that if you are, I think the Commission, for example, should be asking itself if this project is supposedly going to service a purported need in a state or region that has aggressive decarbonization mandates in very short order. Is there genuinely a need simply demonstrated by precedent agreements, even if those precedent agreements are not to fulfill it? I would imagine that there will be staunch opposition to that, but that generally I think that sort of starts to get perhaps a little bit of the confusion you're sensing, Chairman, about when do we do the need determination. I think some of that is a function of what should be part of that need determination, and if you take a very narrow view versus a broader view, some of the factors you might consider later in balancing might also come into that need determination as well.
Ms. Outram?
Chairman, thank you for the question. I would take this back one step in that need is usually identified, and I know that the Commission needs to verify this, but need is usually identified by the market prior to an applicant coming to FERC. I will remind everyone here that these are not small applications. They take tens of millions of dollars, months and months of work. In LNG, it's hundreds of millions of dollars in order to even put forth an application. So the facility owners are going to be determining whether there's really a need to be able to put forth a project. And obviously this is a public need that's the question. So that's a little bit broader question here, but that really is the first step in these applications. And so I think that demonstrates quite a bit of effort on the part of the companies prior to even coming into FERC for these applications.
Thank you, Ms. Outram. I see Chairman Keller and Dr. Tierney have their hands up. Do you want to provide comments? Oh, no.
Thanks. Did you want Sue to go first?
Why don't you?
No? Okay. Just a quick response on the question of need. I agree that we probably would have different conceptions to how the Commission should consider need. One example would be the Commission's gas competition policy since the 80s has been intended to free captive markets that are served by only one pipeline. Now, there aren't that many of those left, but to me, the notion that, well, there is one existing gas pipeline that serves this market, one's plenty, so that second pipeline should be denied because it's not needed. To me, that's squarely inconsistent with the Commission's competition policy because it wants it recognizes that a customer that can choose more than one pipeline is probably going to get a better rate overall, and its customers will be served better. So there is that notion of, well, it's not needed because there already is a pipeline. I just think that would be a dramatic reversal of commission policy. And I also think it'd be inappropriate for the commission to say, well, I don't think this pipeline's not needed because if they have a more aggressive demand response programs and they build wind and solar, they don't need the gas power plants that are intended. I think that is just inappropriate for the commission, since resource planning, at least by utilities, is reserved to the states, and I don't think it's the commission's position to override those state decisions and preferences.
Thank you, Chairman. Chairman Glick, there are no other hands raised. Do you have any other further questions? I think you're muted, but I think I can read your lips to say no, thank you.
No, thank you. That's right.
Other commissioners, Commissioner Danley, Clements, Christie, anything like that?
No, thank you.
This is Commissioner Danley. Very quickly, I just wanted to put a coda on the discussion about the legal authorities, and that is to say that anybody who thinks that there is stability around Sable Trail is mistaken. We still have, as I said, the impending collision. It's going to happen one day with Public Citizen, and the degree to which there's an implicit rescission of Public Citizen and Sable Trail, I don't know that Sable Trail will survive it. And to prove that this isn't a stable field of law, we have a decision from the 11th Circuit that very, very surprisingly directly criticizes as questionable the legal reasoning within Sable Trail. That is not a common thing to happen among appellate courts. And so I just want to remind everybody as we close this panel out that certainty in the durability of Sable Trail is misguided. Thank you, Mr. Chairman.
Thank you, Commissioner Danley. Commissioner Christie, do you have any further remarks?
No, I don't. Thank you. It's been very enlightening, and I hope we'll have a much more extended legal debate over these issues in the future. Thank you.
I want to thank you so much to the panelists for your robust discussion. I think we've learned a lot during the course of this panel. I'd also like to thank the Chairman Glick and Commissioners Danley, Clements, and Christie for this very stimulating discussion. We're going to take a short break and regroup at 11:20 to start panel 2. Panel 1 panelists, please sign out of the WebEx meeting. If you'd like to continue watching the conference, you may use the public webcast link on the conference events page at FERC.gov. Commissioners, please stay signed into WebEx over the break, but mute your microphones and turn off your cameras until we resume. Panelists for panel 2, please sign into WebEx now. And again, we'll start about 5 minutes late at 11:20. Thank you all so much.
Okay, I think we're going to go ahead and start now. I want to thank everybody for returning. And first of all, I want to thank all of our panelists. I also want to go ahead and thank Chairman Glick and Commissioners Danley, Clemens, and Christie for joining us here today. We're going to go ahead and start panel 2. And this panel is really about types of mitigation we're going to talk about. And my name's Eric Tomasi. I work in the Commission's Office of Energy Projects. I'm joined today by my colleague and co-moderator, Catherine Gill-Johan, and she's from the Commission's Office of the General Counsel. This panel, we will be the moderators, and it's entitled, as I mentioned just previously, Types of Mitigation. And this is going to carry us through about 1 p.m., depending on how things go. And following this panel, we're going to go ahead and take a break for lunch. So, just to repeat a few reminders from the earlier panel, we do want to remind everyone to refrain from any discussion of pending contested proceedings. If anyone engages in these kinds of discussions, a FERC staff member will go ahead and interrupt and ask the speaker to avoid that topic. Now, before we get into the questions, again, I want to thank everyone here for joining, and Kat and I are going to go ahead and, after this first question, where everyone can speak basically give their initial discussions, and we'll go through the different, through Chairman Glick and the commissioners. We'll go ahead and we'll do each question after that, questions 2 through 5. The first question we have here, if everyone's ready, is addressed to all the panelists. And I will call on each panelist in turn, similar on panel 1, to give their response. I do ask that each panelist limit their response to no longer than 3 minutes. Now, we do have a varied number of interests that are represented on this panel. And so we are asking each of you, what mitigation solutions are available or have you worked with to address both the direct and indirect, i.e. downstream, greenhouse gas emissions? So first of all, I'm going to call on Ivan Vanderwalt, Chief Operating Officer at Next Decade Corporation. Mr. Vanderwalt.
Good morning, and thank you, Chairman Glick, Commissioners, Catherine and Eric, for arranging us to be on this panel today. Next Decade Corporation is grateful for the opportunity to present our views to the Commission on the important topic of climate change. At Next Decade, we believe climate change is real, and reducing CO2 emissions from industrial scale facilities around the world is critical to realizing the Paris Agreement's goal. We also believe that reliable, competitively priced energy and responsible environmental stewardship are not mutually exclusive. This week, we voluntarily filed with FERC a limited amendment to incorporate carbon capture, storage, and sequestration as a further mitigant to reduce the GHG emissions impact of the Rio Grande LNG facility. Upon full deployment of 27 MTPA of liquefaction capacity, incorporating CCS at RGLNG will capture more than 90% of RGLNG's CO2 emissions, aggregating over 5 million tons per annum. A typical LNG facility emits approximately 30% of CO2 emissions from natural gas pretreatment, with the balance coming from the consumption of natural gas in power generation or compression, otherwise referred to as post-combustion CO2 emissions. Given this backdrop, we initially worked to optimize RGLNG's design, resulting in CO2 emissions reduction of 21.6% relative to our approved initial design. We then focused our technical analysis on how to reduce the post-combustion CO2 emissions from the natural gas consumed by RGLNG's turbines. First, we assessed the use of hydrogen instead of natural gas as the fuel for the turbines, and subsequently the use of electric drives as an alternative to gas-fired turbines. After significant work, we dismissed these options, as they either did not result in a reduction of Scope 2 and Scope 1 CO2 emissions, or they were ruled out due to the significant amount of incremental renewable capacity required to be added to the Texas power market. Following substantial technical analysis, CCS was determined to be a technically viable application at RGLNG. Our value engineering efforts continued, addressing economic freshwater consumption and other design optimization opportunities for CCS. These efforts culminated in the development of a proprietary carbon capture process that is more efficient than other CCS designs. As a result of our CO2 emissions reduction work, Next Decade plans to implement CCS at RGLNG. Based on the work Next Decade has done to date at RGLNG, we believe that utilizing carbon capture and storage at U.S. LNG facilities can reduce the majority of CO2 emissions from the LNG process and is technically and economically feasible. Thank you.
Thank you, Mr. Vanderwalt. Next, I'm going to go ahead and call on Dr. Anna Scott, and she is the Chief Science Officer at Project Canary.
Thanks so much, Eric. First, I'd like to express my thanks to the Commission and the staff for the opportunity to join everyone today, and I really applaud everyone for bringing this topic forward. Project Canary is a Denver-based company. We're focused on emissions measurement, quantification, and certification within the energy supply chain. And we think that one mitigation method that we'd like to talk about is continuous emissions measurement and quantification. We think that independent measurement is needed because of the discrepancy that's been reported between estimations from emissions factors and measurements that are taken. Sometimes these are called the difference between top-down and bottom-up methods. Recent studies have indicated that there are large discrepancies between these two ways of understanding what our emissions are. Sometimes these discrepancies are as large as orders of magnitude. When specifically talking about a midstream or compressor station, this is both in the form of leaks from equipment as well as emissions from methane slip in engines. In the upstream sector, this comes from a variety of potential sources, many of which are intermittent and can be easily remediated. At Project Canary, we have a market-based solution for this that allows operators to go above and beyond, first of which we install continuous and real-time monitoring that not only quantifies these emissions, but also alerts operators to when emissions exceed normal specifications, allowing them to identify and remediate emissions in real time. The data that we collect also allows firms to identify what their largest sources of emissions are and remediate. And we think that measurement is key to managing and reducing emissions. As a note, this is a business model that's received tremendous uptake in the market. To date, we're working with over 50 operators throughout the energy supply chain, and we think that all of this measurement is possible in the market today, and it's not cost prohibitive. To address the question of the indirect emissions that we're considering today for the upstream, this costs only pennies per MCF, depending on the field that we're examining. And we project similar costs for the midstream sector. We think that this is the type of technology that is not only employable today, technologically feasible and affordable, but it can even be helpful for the American energy industry. I think the Environmental Defense Fund recently said that the best thing that the U.S. natural gas industry could do is to focus on measuring and reducing their methane emissions, and we think that this type of technology merits consideration. Thank you.
Thank you very much, Dr. Scott. Next, I'm going to call on Caitlin Tesson, Director of Market Innovation at Enbridge.
Thanks, Eric. Enbridge appreciates the opportunity to participate in this technical conference and recognizes both the importance of the questions raised and the important role of midstream natural gas pipelines like Enbridge in delivering access to cleaner energy. Enbridge has adopted company-wide targets of net zero emissions from operations by 2050 and reducing the intensity of our GHG footprint by 35% by 2030. And we're actively working towards those goals. As Enbridge Director of Market Innovation, I oversee our energy transition efforts, and I'm pleased to share with the Commission and other participants information about what Enbridge is already doing to mitigate greenhouse gas emissions from the construction and operation of our pipeline and facilities, and some ideas about additional steps that can be taken to address those emissions. We employ a wide range of these mitigation techniques, tools in our tool chest, if you will, that can be applied to our pipeline operations and those associated facilities. We proactively take steps to reduce leaks and to minimize the volume of natural gas that is vented into the atmosphere during construction and maintenance. Examples of these tools include the use of pneumatic or electric valve operators, dry seals, electric starters, and we have a robust blow-down collection system process designed to pull down and recompress gas that otherwise would be vented. We're operationally, environmentally, and commercially warranted using electric compressors for new compression capability, and in some instances, powering those electric motors through Enbridge-owned renewable resources, i.e. solar. Enbridge has the only two operating solar behind-the-meter projects powering electric compressors in North America, offsetting a portion of those stations' power, and we continue to grow that program. At the end of the day, if I leave you with anything, it is that there is no one-size-fits-all solution, and physical mitigation techniques. In deciding what forms of mitigation may be appropriate at a particular site, we must carefully consider a range of factors, including operational limitations to ensure reliability, commercial considerations, customer preferences, regulatory requirements, landowner interests, and more. It's a lot to get into, and I look forward to discussing this further on the panel. Thank you.
Thank you very much. I appreciate those comments. Some of those comments are very interesting. We'll probably come back to some of your comments regarding your gas capture. Next, I want to call on Harry Choquette, Executive Director of Research and IT at the Pipeline Research Council International.
Thanks, Eric. I appreciate the opportunity to participate. The solutions to reduce greenhouse gas emissions, especially for the transportation of natural gas by pipelines, they're too numerous to really get into any great detail here. There's many, many different ways to tackle the problem. The key is going to be tackling the ones that have the biggest impact first and the ones that are most economical. And that's often a challenge for operators to do because there's so many options to look at. So we really need to migrate to the point where we're looking at greenhouse gas emissions on a net present value basis, carbon economics, if you will. And that needs to include carbon dioxide emissions as much as it does methane emissions. We focus a lot on methane emissions. We need to. They have a higher greenhouse gas emissions factor than carbon dioxide, but our biggest footprint is still carbon dioxide from combustion sources. So there needs to be as much focus on improving the efficiency of the transportation system as well as reducing fugitive emissions from methanes. We also need to be looking at alternative fuels. Hydrogen economy is possible alternative, but the biggest bang for the buck is really renewable natural gas from a net present value from carbon emissions, by and large. So there's a lot we can do as an industry. There's a lot of solutions already out there. In some cases, the solutions are technically available, they aren't necessarily economically available, or there's regulatory inhibitors that prevent their implementation. So we need to look at it comprehensively, and if there's cost barriers, that's where research comes in. What can we do to develop new technologies to reduce those cost barriers? But that's only one part of the picture. We really need to tackle it as a holistic approach from all aspects. Thank you.
Thank you very much, Mr. Choquette. Next, I'm going to go ahead and call on Suzanne Walzer, I apologize, Deputy Branch Chief at the Environmental Protection Agency.
Good morning, and thank you for having me on the panel today. As Eric mentioned, my name is Susie Walzer, and I'm in the non-CO2 programs branch at the U.S. Environmental Protection Agency. We're the group that implements the methane mitigation voluntary programs. For those who are not familiar, since 1993, EPA has collaborated very closely with the oil and gas industry through a program called the Natural Gas Star Program. And that program was designed to facilitate the implementation of voluntary, cost-effective, and proven methane mitigation technologies and practices. To provide a mechanism for companies to make even greater and more ambitious and transparent commitments to reduce methane, we also launched a second partnership in 2016, and that program was called the Methane Challenge Program. So through this nearly 30 years of collaboration with the oil and gas industry, we have developed a detailed suite of technical information on mitigation measures that reduce methane across the entire oil and gas value chain. This includes solutions that reduce methane emissions resulting from normal operations, routine maintenance, as well as fugitive leaks and system upsets. So just to give a brief example, one of the top reduction activities that have been reported for the transmission sector is reducing or minimizing pipeline blowdown emissions. And this is the top pipeline-related emission source in the current greenhouse gas inventory. And this was done through a number of technologies and practices, such as routing gas to a compressor or capture system for beneficial use as opposed to venting to the atmosphere. So using these types of mitigation approaches, our partners have reported reducing their potential emissions from non-emergency blowdowns by roughly 5.9 million metric tons of carbon dioxide equivalent since the program began in 2016. So this is one of our top technologies. In addition, we have a lot of information on leak detection and repair programs for both compressor stations and pipelines. And of course, these can become more effective detecting pipeline leaks with the use of advanced technologies and aerial surveys to cover larger areas. We also have a lot of information on compressor station equipment-related mitigation. I think that was mentioned earlier. Solutions such as monitoring and replacing rod packing and replacing wet seal compressors with dry seals. For LNG, we have less information directly through the voluntary programs, but the mitigation options would be very similar to that of compressor stations. And finally, I just wanted to briefly mention, in addition to voluntary actions, the EPA recently proposed new source performance standards and emission guidelines for existing sources. And so these would do two things: expand the emissions reduction requirements that are currently on the books for new, modified, and reconstructed sources in the oil and gas industry. And the proposal would also require states to reduce their methane emissions from existing sources nationwide for the first time. So this is a very brief overview of our experiences. I look forward to the discussion, and thank you again for having me on the panel.
Thank you very much, Ms. Walter. Next, I'm going to call on Bill Donahue, Manager of Natural Gas Resources at Puget Sound Energy.
Good morning. I appreciate the opportunity to speak today on behalf of Puget Sound Energy and the American Gas Association and its members. It's an important issue, and we look forward to the discussion. The gas industry has a proven track record of reducing emissions, and AGA members will continue to collaborate with stakeholders to further reduce emissions. I've provided some insights in pre-filed comments, and I expect that we and AGA will be filing post-technical conference comments. On the Puget system, we mitigate greenhouse gas impact in three categories: upstream, midstream, and downstream. There's a number of names for it. And I'm sure many of these mitigation measures are not unique to PSC. All of these measures ultimately reduce greenhouse gas emissions associated with the use of natural gas and should be considered as viable mitigation to greenhouse gas emissions implied to originate from FERC certificated facilities. First, on the upstream, we do a number of things. We acquire natural gas, in our case, from low emissions production areas. This is our case. We get over 50% of our gas from British Columbia, which has some of the tightest mitigation requirements in place and has a world-class greenhouse gas monitoring and reporting system. On RNG, we are currently have acquired 2 to 3.5 BCF of RNG and have ambitious goals to get to 9.5 BCF, nearly 10% of our sales load by 2030. We're also actively involved in looking at responsibly sourced gas, which can be certified, and looking at blending of 5 to 10% hydrogen on our system. In the midstream category, we are working with one of Mr. Hallam's pipelines, Williams Northwest, and with Miss Tesson's pipeline, Enbridge West Coast, to replace equipment with lower emitting components and compressors, and modifying operating procedures, as previously mentioned, especially with regard to blowdowns. We are utilizing our pipeline capacity today to move RNG, and we have tariffs in place to allow movement of RNG on our distribution system for third parties. We've contracted an aggressive internal methane leak identification and remediation program, going far beyond current industry standards. If we know there's a leak, even though it may be below a safety threshold, we resolve the problem. And in the downstream area, again, we have a number of energy efficiency programs, which reduce load on a cost-effective basis. And as a side note, though not all parties agree, we have been ordered by our legislature in Washington to incorporate the social cost of carbon in the analysis of the appropriate level of energy efficiency and conservation. The end result has been a significant cost justification for higher levels of efficiencies. We have introduced voluntary RNG programs, voluntary carbon offset programs for customers that wish to have more than the standard application of renewable products. And we are working to develop hybrid heat pumps as an alternative to natural gas only furnaces. This is an important function that will allow moving some of the energy needs to electricity in off-peak periods, but without overwhelming the electric grid during peak weather events. Along with an unregulated affiliate, we've constructed and put into service a state-of-the-art LNG peaking facility, which is actually a combined use or dual use facility that that fuels marine vessels and local trucking, in addition to serving as a peaking device on our system. That has resulted in not applying for additional pipeline capacity. And I should mention, as a part of that, we've been through a full life cycle greenhouse gas study. And on that notion, it's a comment toward the first panel. If FERC is to consider indirect greenhouse gas emissions, it must, in our opinion, and that is Puget Sound Energy's opinion, do a comparative analysis, a with and without, if you will. It cannot simply be assumed that without the pipeline, energy needs will be served, or that they will be served with a lower emitting resource. And I think that, and one other observation, load factor matters. As an LDC, we're serving a 25% load factor market. We achieve a 50% load factor on our pipeline utilization, and we're in a unique situation in that we serve half of our load in the winter with storage. So load factor does matter. Thank you.
Thank you very much, Mr. Donahue. It's interesting to hear that perspective from LDC. Next, I want to call on Dr. Nikki Sheets, the Director of the Center for Urban Environment at the John S. Watson Institute for Public Policy. Dr. Sheets.
Thanks, Eric, and I want to thank the Commission for inviting me to speak. So I work at Kane University, which is a college in central New Jersey, at a policy institute, as Eric has indicated. But I work mainly with the grassroots environmental justice movement in the United States, and I help the movement develop the best possible public policy from an EJ perspective. And I'm not as steeped in some of the technical aspects of the issues that the Commission normally deals with, but I think I've been invited here because they want at least a glimpse into, you hear me say EJ for environmental justice, into the EJ world and our world view. I'll start by saying the environmental justice movement's main objective is to protect communities of color and low-income communities. And because of that, and our main focus is to protect it from the disproportionate pollution loads that often are inflicted upon these communities and the health consequences of this disproportionate pollution. And because that's our main objective, sometimes we're driven to different policy points than policymakers, environmental policymakers, the environmental movement, and the private sector. And the case in point is climate change policy. So we bring a different paradigm to this. my answer to this question is that what we focused on is making sure the climate change mitigation policy, or trying to make sure the climate change mitigation policy not only fights climate change, but also addresses the disproportionate pollution load that many EJ communities, EJ for environmental justice, suffer from. So we want to make sure the climate change mitigation policy not only fights climate change, but that it also reduces locally harmful greenhouse gas co-pollutants while it's fighting climate change. Because these co-pollutants form part of that disproportionate pollution load. So we have focused on identifying power plants that are located in environmental justice communities and forcing them to reduce their emissions no matter what type of climate change policy that they fall under. We have said that if a strategy does not guarantee emissions reduction in EJ communities so that we get that co-pollutant reduction, as well as fight climate change, then that strategy should not be used. So this point of view that you focus uniquely on protecting EJ communities has moved us to policy positions where we don't generally support market-based mechanisms. And I don't speak for the entire national EJ movement, but most organizations, many don't support market-based mechanisms. We take more holistic points of view. We don't support CCS. We don't support offsets. We want to focus squarely on those strategies that will not only fight climate change, but will improve the health of local communities by reducing co-pollutants. And I hope, as you ask more questions, I'll get to give you more of a glimpse of our worldview. Thanks, Eric.
Thank you very much, Dr. Sheets. Kat, I believe you had a quick question.
Yes. Thank you, Dr. Sheets, and all panelists for your responding to that intro question. I will give the panelists, the chairman, and commissioners an opportunity to follow up. But before I do so, Dr. Sheets, if I could follow up with a question to build a little bit off of your intro, if you could perhaps speak a little more about best practices, like when and how the commission or a project developer should engage and work with EJ communities when drafting or considering mitigation proposals. And that could be whether it's drafting a physical or market mitigation proposal for a project that is going to impact EJ communities.
Well, I think at this point, where we are heading with this and who we're trying to impact are the policymakers, and we would include FERC in that, by the way, as policymaker. Policymakers on both a national and a state level. We did a lot of work on the Clean Power Plan. We are attempting to engage our state in New Jersey right now on what we call a mandatory emission reduction proposal, which means let's identify power plants, in EJ communities and force them to reduce. And it would be difficult to go project by project. This is a strategy that we think, or program that we think must be planned and implemented in a cohesive and coherent fashion, because different projects will all play their part. So I think what needs to happen now is that the governmental agencies, and again, that includes both federal level and a state level, needs to meet with the EJ community and say, okay, how are we not only going to fight climate change, but make sure that we center equity while we're doing that? And that's not what has happened thus far. And look, we think that costs need to be taken into account, but right now we see that the universe places, or the energy universe of the United States places costs at the center of things. And we think that should be a constraint rather than a goal. So it's going to take a rethinking of how the energy system works. But since we're going to reduce emissions anyway, we think it should be done in a way that will guarantee help to the EJ communities that need this help so badly.
Thank you, Dr. Sheets. I want to take the opportunity to open up the floor to the chairman, commissioners, other panelists. If there is a follow-up question after that introductory statement, we can take those questions now. And folks could use the WebEx raise hand feature. That will give us an opportunity to call on folks in order. Chairman Glick?
Chairman Glick, I believe you're muted.
Still on interview. Yes. Commissioner Danley, do you have any questions for the panel?
Thank you. No questions at this time. I appreciate it.
Commissioner Clements?
Thank you, Kat. Mr. Donahue, could you follow up and say some more about how you're using the social cost of carbon to monetize and to implement your obligations pursuant to state requirements?
Yes. In Washington, all gas and electric utilities, and we're a combination, utilize integrated resource planning, which is a 20 to 25-year view of the future, and consider new resources for growing load or replacement resources for evolving legislative requirements. In our case, we have the CETA, don't recall the exact acronym, but it is essentially we will be eliminating all greenhouse gas emissions on the electric side by 2045, and a significant reduction by 2030, whereby we have to offset all emissions from existing resources. So, in considering, and on the gas side, in considering, do I build a pipeline or ask one of the interstates to expand for me, or do I build a storage facility, or do I do more conservation for the growing load in the Seattle area? We add to the long-term view projected price of natural gas, we add in the social cost of carbon to that molecule of gas. And so I think in this case, it looks to add something in the neighborhood of $10 a decatherm to a long-term price of gas in the basins we operate. And the result is it's economically more feasible to spend some of the money on doing additional conservation programs, load reduction programs, efficiency programs, than it is to build that next increment of supply. I hope that helps.
Yeah, sure. Thanks. Kat, I'll turn this with you, if the chairman's back, but I appreciate that, there's not a one-size-fits-all approach necessarily across projects, but if panelists have thoughts on how social cost of carbon may or may not be appropriate in your case, I'd appreciate hearing it throughout the course of the panel.
Thank you, Commissioner Clements. Commissioner Christie?
No questions. Thank you.
Thank you. And Chairman Glick, let's see if we got your audio back.
Can you hear me now?
Yes, you're back.
Great. Thanks. Sorry about that. Two quick questions, hopefully. First of all, Mr. Schatzman, and I want to be careful because I know there's a pending proceeding before us, so I don't want to violate any restrictions. But you had talked about carbon capture and sequestration and your ability to, I think, reduce greenhouse gas emissions by 90% at your proposed LNG project. I'm assuming, because you're proposing it, that you believe you can do that in an economic way and still become a profitable facility.
I think that's Mr. Vanderwalt, who is calling in for Mr. Schatzman today. There was a last-minute change.
Yes, Chairman Glick, I was also having mute problems there. You're quite right. In fact, the 45Q program is quite favorable here in the U.S. for this very purpose, for the compensation of carbon capture and sequestration processes.
Well, thank you. I know 45Q is I think people are getting a lot more interested in that program now because the technology has advanced. Moving over to Dr. Sheets and Ms. Walter, I very much appreciate your testimony, and Dr. Sheets in particular. This is an area that we are, quite frankly, struggling with, environmental justice. This is a relatively, even though we consider the issue underneath, but for us, we're trying to enhance our review process and trying to, I think, do it right this time, so to speak. And one of the things I know, as we were talking about with regard to environmental justice communities, in terms of citing these particular projects, is you mentioned the co-pollutants. And sometimes the co-pollutants, NOx and SOx, let's take those two as an example. There are federal standards associated with that. And sometimes there's a question if the pipeline company or the LNG company is going to meet those federal standards, are we able to do we need to require further mitigation beyond those standards? Lower the NOx and SOx emissions even below what the federal requirements are because it's an environmental justice community. And, the communities have already been adversely impacted by other projects, for instance, maybe. So I'm curious if you've got some thoughts about whether we need to go below the standards that exist in terms of regular EPA Clean Air Act standards.
Great question, Chairman Glick, and you actually kind of gave the answer in your question. We are really focused, and arguably the most important EJ issue today is called cumulative impacts, and that's really about how do you deal with multiple sources of pollution in communities. Unfortunately, our communities of color and low-income communities suffer from this a lot, and our country doesn't deal very well with it because we set individual standards. We go pollutant by pollutant. We set individual standards that typically do not take into account the total amount of pollution, that soup of pollution in the neighborhood. And so this is almost exactly why we've developed this policy that says that, look, if we're going to have power plants reduce emissions, let's make sure they do it in EJ communities, because by using climate change mitigation policy in conjunction with those other policies that are already being used to address criteria pollutants like NOx and SO2, and really the one we focus on a lot is fine particulate matter, hopefully we'll be able to drive concentrations of these pollutants, both individually and especially together, to levels we've not been able to achieve thus far by using the strategies that are already on the books. We need to drive all these pollutants to lower levels. Take, for example, fine particulate matter. The scientists telling us that even if an area meets the local standard, it's still killing people by itself. That's not even when you take into account how it combines with other pollutants and with social vulnerabilities that exist in these neighborhoods, right? Higher disease rates, less access to health care. And so we want to use climate change mitigation policy as a way to help us drive concentration of these pollutants lower than they are now. And we think it's desperately needed. Our communities right now are being legally polluted to death. We've made a lot of progress. I'm not going to say we haven't. But especially in EJ communities, in areas where you have these multiple sources of pollution, we desperately need more progress. And we can save lives by using climate change mitigation policy in this manner. We will save lives we've not been able to save thus far if we do this. And so, yes, you need to go beyond what's on the books now with NOx and SOx and fine particulate matter.
Appreciate that. Ms. Walter, I don't know if you have a thought from an EPA perspective.
Nothing that specifically in terms of levels, but I will say that the impact community was very important to understand for the agency, and that there was a very extensive effort to reach communities pre the recent proposal as well as through our voluntary programs. So it's something we continue to really prioritize and make sure we're understanding the impact to communities.
Thank you.
Thank you, everyone. We're going to go on to our next question. To use the gas term, we'd like to drill down a little bit further on physical mitigation. We had some good opening conversations on a few mitigation methods and tools. So this question hopes to build on some of those intro comments we heard. What type of physical mitigation associated with greenhouse gas emissions are project sponsors currently using at their facilities? What type of physical mitigation associated with greenhouse gas emission are project sponsors currently available to project sponsors, but maybe not being implemented? And how much mitigation is actually occurring through physical mitigation measures? And I guess I'll tack on one more of, are there any limitations or concerns with using physical mitigation measures for GHG emissions? And we are queuing. So first start with Mr. Duquette. You go first.
Thank you very much. So the research that we PRCI have done on subpart W data that's been reported to the EPA on methane emissions specifically shows that the pipeline operators have done a good job of reducing methane emissions using a wide variety of techniques to reduce emissions. But there's a whole lot more that can be done in that area. But one of the major aspects that we've done is just focusing on the integrity of the pipe itself, and therefore not having to blow down the pipeline to effectuate repairs. So whatever we put in place, we really need to make sure that we don't create incentives to reduce the integrity of the physical asset. You've got to keep that safety high because it does help reduce our greenhouse gas footprint, not only from the direct emissions, but indirect emissions from repairs and the likes. And like I said in my opening comments, efficiency is maybe the overlooked child. A lot of people have done efforts in that to reduce fuel consumption on pipeline transportation, but that's one of those that it really, for a pipeline operator, you're limited into how much you can do in that realm based on what you can recover in the associated costs. And that's one of those areas where there are some regulatory challenges to that. The other thing that is a challenge is there are times when we can't use portable compression to reduce pipeline blowdown because we can't get timely air permits, as an example. So again, looking at things holistically and how do we structure everything to help the operators be more agile in tackling those emissions would be helpful. Thanks very much.
Thank you. Mr. Donahue?
Yes, in addition to some of the other things mentioned, there are pipeline replacement programs. We have, for example, identified the most leak-prone aspects of our system and have completely replaced all of our cast iron pipe and most of our bare steel pipe in an ongoing program, which was fully supported by our regulator. We are replacing valves. We're studying valve technology not only to reduce methane emissions, but also to consider viability in a hydrogen blend scenario. So there are a number of measures. There are, at least in our area, subcontractors that will provide recompression equipment for the occasional cut into the system where you have a potential for blowdown, and we have been able to successfully reduce emissions. And the pipelines we work with have undertaken those efforts in part by the customer's request. So all of those features are available.
Thank you. Ms. Tesson?
Thanks. I just wanted to comment, and I agree with what Gary mentioned. At Enbridge, when we think about reducing our emissions, we think about 4 pathways: modernization being one, innovation being another, utilizing and moving lower carbon energy. So I know that Mr. Donahue has spoken a lot about RNG. We're actively investing in RNG and exploring hydrogen. And then I know later we'll get to offsets, but that's the last of our pathways. And so when we think about physical mitigations, I wanted to just touch on, and I think Ivan might be coming up after me, but from a carbon capture perspective, I think about that really in 2 different paths, both pre and post combustion. And I think the number one thing that we're trying to do, and we're tweaking our operating practices and we're investing in technologies, is to make sure that first is about prevention, right? It's making sure that our compressors have pressurized holds and no vent pneumatics. And then when blowdowns are necessary, either on our pipeline or at our compressor station, is minimizing those gas releases as much as possible through those pull down or pump downs and recompression where available. So I think those are all very important to consider and to think about, is the physical mitigation of making sure that we're not releasing the atmosphere as much as possible. And then the last piece is that post-combustion piece, and I believe Ivan will speak about it next, but from a gas turbine compressor perspective, we're actively reviewing this technology. I think that there are some things for us to consider related to where the CO2 goes. If from a geological perspective, it's not logical to drill a hole right next to our compressors, and what that technology really looks like, and other engineering considerations. But certainly, I think innovation and technology continues to be something that we're chasing on our side.
Thank you. Mr. Vanderwalt?
As I stated earlier, Next Decade's planning to implement CCS at the RGLNG facility, which will reduce our CO2 emissions by over 90%. Prior to Next Decade's work on CCS at RGLNG, available GHG mitigation measures included four main areas: efficiency in energy production and consumption through process engineering, design advancements, equipment improvements, maintenance plans, performance metrics, fuel mix, and other operational variables which can have a meaningful impact on lowering the GHG emissions. Secondly, upstream endeavors focus on design operational aspects, as mentioned earlier, such as best practice well construction techniques, continuous monitoring of methane emissions, as Dr. Anna mentioned earlier, and quickly fixing the leaks, reduction or eliminating gas flaring, taking steps to minimize negative impacts on air, water, land, and EJ communities, as mentioned earlier. Hydrocarbon processing and transportation businesses, they manage the emissions through design, monitoring for fixing leaks, the energy choice, the energy mix. For example, the use of renewables in the energy mix, electrification versus gas-fired compression stations, as again mentioned earlier, maintenance schedules, performance metrics, process designs, for example, venting versus sequestration, pigging operations, blowdown events, acid gas removal systems, and scrubber systems, which are prevalent across many downstream industries. But venting versus utilization or sequestration of separated components varies. The selection of energy mix, process engineering, design advancements, equipment improvements, and maintenance plans, as well as performance metrics and other operational variables, are all deployed routinely to optimize operational performance and thus impact the levels of GHG emissions. As far as your question on limiting limitations of physical mitigation measures, next decade's not aware of any technology, process, or application that can physically eliminate 100% of GHG emissions, especially CO2 from natural gas pipelines and LNG operations. However, known technologies and processes and applications can meaningfully reduce the GHG emissions to levels that enable realization of the Paris Agreement goals. And we are playing our part by incorporating CCS at RGLNG to reduce those CO2 emissions by greater than 90% of our permitted value.
Thank you. Mr. Choquette, do you have a follow-up question? See your hand raised?
My apologies. No, I don't.
Okay, just checking. Then I'll go to Dr. Scott.
Thanks, Kat. I just wanted to echo the comments of my colleagues that at Project Canary we see a couple of different ways that firms are reducing their emissions, both in the upstream and the transportation sectors. Those are typically differentiated by equipment investments. So engineering investments where folks have perhaps electrified compressors or have moved to different forms of equipment that are by nature by design, are going to reduce less. This probably a little bit too complicated to get in all of those, but my colleagues from the EPA have mentioned some of those methods. We also see that investment in practices, in particular leak detection and repair operational practices, can significantly reduce emissions as well. We see that throughout the sector. When we talk about how effective we see this getting, certainly no emissions can be difficult for a variety of safety reasons. But certainly one thing that we see is that because methane as a greenhouse gas has so much larger of an impact than carbon dioxide, we do see that when firms throughout the supply chain reduce their methane emissions, they achieve significant reductions in their overall greenhouse gas impact, and that does include combustion. I think recent analysis that came out from research done by Cheniere that was published and peer-reviewed indicated that they could get pretty significant double-digit reductions in the total greenhouse gas impact simply by focusing on reductions in those emissions throughout the upstream, the production, and then the gathering, processing, and transportation sector.
Thank you. Ms. Walter?
Yes, I just wanted to add to the discussion earlier about limitations. Though the limitations or the key considerations will vary depending on the project, but just to note, something that we have heard from our partner companies is really minimizing the downtime, especially from transmission companies, as being one of the limiting factors, and that the way they've overcome this is by staging or implementing projects, both in pipelines and compressor stations, in a way that will minimize the downtime, such as by kind of grouping together activities. So when you take something offline, you do everything at once. Just wanted to note that as something we've heard through our program.
Thank you. This is Eric Tomasi. I have a quick follow-up for the panel. It's regarding carbon capture. Specifically, what has the industry seen for feasibility for smaller sources, like compressor stations? Additionally, what are you looking at for the efficiency of carbon capture generally when you're looking at these facilities? When I say efficiency, I don't mean how much you're capturing greenhouse gases, but specifically, this is a process. The carbon capture is a process, the compression is a process, and that there's energy or power needed for that processing, compression, transport, and in case of sequestration, actual injection. If you could talk a little bit about those, as well as Dr. Sheets' concerns about non-removal of criteria pollutants during the processing. How are these treated in the processed gas, that sort of thing. Thank you. Anyone want to respond to that? It's a rather technical question, but that's why we're here. Mr. Choquette. So
I'll take a crack at that. there is a lot of research around carbon sequestration, but the majority of it is related around coal, sequestration of CO2 with coal sources. A lot of the principles still apply as far as the technologies you would use, for example, to scrub an exhaust gas stream to remove CO2. And so we know what those technologies are and the limitations of them. And, you know, a lot of them will use a chemical process to extract that. There will be some additional emissions of VOCs from those chemical processes. So you need to, again, look at it holistically, that what you're doing to reduce greenhouse gas emissions, you don't create a social justice issue by having, you know, benzene or some other emission associated with some of those technologies. One of the biggest challenges the natural gas industry is going to have with sequestration is, what do you do with the CO2? And in many cases, the only answer is to build additional pipeline infrastructure to get it to a place where you can pump it back down below ground. There's other options, but for the types of quantities that we're looking at, really, that's the only feasible option. And so again, you got to look at the overall economics of that and the environmental impact of you know, building that extra infrastructure to do that.
Thank you. Dr. Sheets?
Yes, thank you. Thank you, Eric. I just want to say I think you pointed out one issue that we might have with sequestration, but I didn't want to make it seem like that's our only issue. We have other issues with CCS. We worry about the transport of pipelines and where those pipelines will be, and they, you know, what might happen to them. You may have leaks, or they may be disrupted. We worry about whether, you know, another panelist said, yeah, what do you do with the carbon dioxide? Is it really going to stay in the ground forever? And what happens if there are leakages there? And I have to say, just and I think you're really going to run into this problem with a lot of communities. The communities have been dumped on already have too much pollution, and we have a history in the United States beyond the environmental area of not dealing with communities of color and low-income communities very well. So to many communities, and you'll hear this a lot, this looks like a big experiment, and the communities don't want to be the subject of those experiments. And you know what we say, and this is in line with our worldview, if we're going to take risk as a society, because what's going to happen trying to bring CCS up to scale? We're going to take risk. We would say it's a smaller risk to really put efforts, all we can, almost like a World War II effort, behind renewable energy and energy efficiency. We really need systemic changes, and we don't want to do anything that's going to prolong our reliance on fossil fuel. We got to do it sometimes, so we might as well start now. And that's in our view of systemic change. You know, to fight environmental justice, you're going to have to fight racism and discrimination and classism. And we're going to, and as we reorder our society to take care of the energy crisis, we're going to have another shot at fighting all these things and doing it in a way that we think we really needs to be done. We know that's not easy, but we think at some point we're going to have to do it, so we might as well do it now.
Thank you, Dr. Kat, I believe you had a quick question?
Yeah, I have a follow-up. I would like to stay focused on physical mitigation for a moment. A lot of what we've been talking about really relates to the direct GHG emissions at facilities. I was hoping some panelists might be able to speak a little bit about indirect emissions and the use of physical mitigation for indirect emissions. As we mentioned in our notice, we were interested in discussing environmentally based mitigation measures like wetlands or planting trees. And I was wondering if any panelists would like to offer some perspectives on the options regarding physical mitigation with regards to indirect. Dr. Scott?
if no one else, I'll say from our point of view, I'll tell you what we, I think I've kind of said what we want to achieve by physical mitigation or other methods. We think in an ideal world, you would use whatever methods would maximize co-pollutant reduction while achieving carbon dioxide or methane reduction goals. Right? Ideally, that's what would happen. But you kind of hit a nerve when you say planting trees or doing other mitigation methods. What we would say with things like that is that whatever you're going to do, it should be in the community where the emissions are happening. So, we don't want to be in Trenton, which is central Jersey, and have mitigation in Camden, which is South Jersey, because you want to mitigate at the, within that community that's being harmed by the emissions. So, we favor mitigation with things you said about planting trees and green space and things like that, but it should happen in those communities that are actually suffering from the emissions.
Thank you, Dr. Sheets. Dr. Scott?
Yeah, thanks. I hope this is going to address your question. Certainly, I think my perspective is that focusing on indirect emissions from the transportation sector should probably start with a reduction of emissions in the production sector, which I think addresses some of the concerns that Dr. Sheets is bringing up initially, focusing on reducing those emissions at the source to start. And that's certainly something that we see is possible, technologically feasible. While I am a Texan by heart and by residency, my company, Project Canary, is based in Colorado, where we've had regulation around a number of sources, both VOCs as well as methane. And what that has allowed the industry to do is to implement a number of technologies, both on the practice side and the engineering side, that have significantly reduced emissions. And indeed, we see quite low emissions rates in the state as a result. And so those are things like, the elimination of venting, the centralizing of processing facilities, the electrification of compressor stations, as well as enhanced frequency of leak detection and repair. And on top of that, maybe to talk to maybe more of the nature-based solutions, one thing we are seeing is that there is interest from the production community. Once they've undergone some of these investments in improvements both in practice and in engineering, to then start thinking about layering on top nature-based solutions. In particular, I think it's now public that Pure West Energy, which is an operator in the Pinedale Basin in Wyoming, is working together with a local nature-based organization in order to offset their remaining emissions once they've already invested in reducing those to produce a net zero on Scope 1 and Scope 2 emissions.
Thank you, Dr. Scott. We're going to move to the next question now. We're going to switch gears a little bit, moving from direct to more market-based approaches. And so the question is, for the panel, what types of market-based mitigation associated with greenhouse gas emissions are project sponsors currently using? What type of alternative or market-based mitigation associated with greenhouse gas emissions are currently available? What is available out there to sponsors? And although it doesn't meet some of the concerns Dr. Sheets had, what available market-based alternatives are there if you cannot do market-based, if you can't do direct mitigation? I guess let's go ahead and call on Mr. Donahue. You raised your hand.
Yes. There are a number of commercially available products out there and platforms that will certify and record and account for a number of credits in a broad category of carbon reduction. One in response to the prior question, I noticed yesterday there is a platform now transacting in what's called an NGEO, or a nature-based global emission offset. And I didn't get into all the description of what nature-based is limited to, but that is an option. We utilize Green E, I believe it's CRS organization in California that will certify a renewable gas program. And then there are a couple of platforms. The one we will be utilizing is the Midwest Renewable Energy Transfer System, MRETS, that will record and document and validate actual efforts made to reduce emissions. MRETS will be tracking for us what they call renewable thermal credits, a unit of RNG displacing a unit of natural gas has a value. Under our state program, we will be retiring 1 unit for every renewal, and we'll create one and then periodically retire those. But those products are also tradable. So in the event that a market has exceeded their requirements, that those products can be sold to another party that does not have access to, say, renewable gas or other technologies. So there are products out there.
Okay, thank you. I believe, Caitlin Tesson, you have your hand raised?
Thanks, Eric. Yeah, I mean, I think, as I said before, one of our pathways at Enbridge is certainly carbon credits and offsets, and I think, you know, we continue to explore, you know, the viability of offsets. Not all are creative equal. You know, research shows that some are effective, but others might lack additionality and permanence, and so we just want to, you know, make sure that we're making a good choice if we're gonna go down that pathway. I mean, certainly, I think from a Scope 2 or from a power emissions perspective, we, you know, are considering and looking at offsetting our Enbridge's Scope 2 emissions by either utilizing RECs, renewable energy credits, from our existing projects in our power portfolio, or by buying RECs. So I think there's certainly a place. It's not the silver bullet. Offsets and RECs are not the silver bullet, but certainly there's a place in it alongside physical mitigation.
Thank you very much. Next, Ivan, you're up next.
Thanks, Eric. Voluntary verified emission reduction credits, also known as VERCs, as contemplated in the Paris Agreement, are available to project sponsors to help offset their project's GHG emissions. However, they currently cannot be relied upon to mitigate meaningful amounts of emissions due to lack of sufficient volume, limited transparency and quality, and inability to guarantee the availability of market-based mitigation measures over the life of a project.
Thank you. Next, Dr. Sheets, I believe you have your hand raised.
Thanks, Eric. I just wanted to make explicit, I refer to our opposition to market-based mechanisms. And obviously you get it, Eric, because you said it doesn't address some of our issues that are reducing at the source. But let me just say explicitly, you know, one of the problems we have with market-based mechanisms and our Native American part of the EJ communities is more holistic. So they have a whole other set of issues. Is that, you know, we want those plants located in EJ communities. We want to guarantee they reduce their emissions. And under market-based mechanisms, there typically is not a guarantee. Now, we're not saying that there won't be any reductions in EJ communities. There undoubtedly will be some. But under a market-based mechanism, a pure mechanism anyway, you'll always be left to wonder, well, how many EJ communities will receive reductions, which ones, what will be the extent of those reductions, and over what time period will they occur. So that's part of our problem market-based mechanisms. Now, what we have said is, for example, in New Jersey, we are part of RGGI. Our state went into RGGI over the objections of the EJ community, Regional Greenhouse Gas Initiative, for those not in the East. And we said, okay, if you're going to do that over our objections, well, at least then do our mandatory emission reduction proposal. Identify those plants in EJ communities, and even if it's a market-based mechanism, make them reduce their emissions. So at least the market-based mechanism is a little bit more EJ friendly. So I just wanted to say that explicitly. Thank you.
Thank you, Dr. Sheets. Next, Dr. Scott, do you have your hand raised?
Yeah, thanks. I just wanted to maybe pull on a slightly different thread. I know my colleague, Mr. Donahue, mentioned his firm's focus on a responsibly sourced or a differentiated gas product. And I know, when we start to think about the offset conversation, one thing that we see happening that's a slightly different market-based approach is this idea of potentially passing through some of the costs. I know this starts to get into what's going to be panel 3, but given that we see significant reductions that occur when operators and transporters start to invest in more environmentally friendly technology, we do see that is something that is a market-based mechanism that's starting to firm up and come together and be a little bit more directly linked, I think, than some of this question of a nature-based offset, perhaps. But rather to sort of say, hey, there was a somebody invested in, whether it was removing flares, installing processing lines. There's a variety of different techniques that we hear. I've even heard of utilities that put in like gathering lines, which that's a heavy investment. To take those reductions and link those up along the supply chain. And in that case, what we do at Project Canary is we actually provide the measurements that can demonstrate that those reductions have actually occurred and provide those measurements. And so it's a little bit different, I think, than the carbon credit conversation, but rather it's more of a measurement-based approach. And that's something that we're seeing coming together in the natural gas markets. We're seeing a number of utilities who are stepping up their commitments in that regard. I think based off of some of the skepticism we hear in the industry with regards to the carbon credit conversation.
Thank you.
Thank you, Dr. Scott.
We both are appreciative. Thank you so much. Before we proceed to the next question, we want to, since we've covered a lot of ground on both physical and market mitigation measures, we want to give an opportunity for the chairman and the commissioners to ask any questions that they might have. So I will first kick it over to Chairman Glick to see if he has any follow-up questions.
I don't have any additional questions. Thank you.
Thank you. Commissioner Danley?
No, thank you. I appreciate it.
Thank you. Commissioner Clement?
Thanks. I'm good, Kat.
Okay. And Commissioner Christie?
Thanks. No questions.
Great. So that means we have plenty of time for the next question, which is wonderful. So thank you, panelists, so far for all of the responses we've been getting. The next question we would like to discuss is how should project applicants submit mitigation proposals? Should it be with their project application? How soon could a project applicant be able to supplement their record or respond to a commission data request with mitigation proposals? And what sort of factors should the commission consider in evaluating the sufficiency of a mitigation proposal? Give everyone an opportunity to digest that very meaty question, and then we can jump in when panelists are ready. Mr. Donahue, you are first.
I certainly didn't mean to be first. I will observe, having participated as a customer in several certificate applications over the years, that I think we've gotten to the point where the customers of a pipeline expansion or a facility rebuild, if it's specific to a customer, probably need to be working more closely and be perhaps part of the application process. I know in the past, and I don't want to change any of the legal foundation here. I'm not opining on that, nor am I opining on behalf of the AGA on this regard. But it seems that simply having a contract was at one time considered demonstration of need. I think if we are in fact going to consider indirect greenhouse gas emissions, there needs to be a more thorough explanation of what the specific need is. In the case of which Northwest Pipeline had many years ago, an expansion purely to provide natural gas to new power generation that was replacing coal, that was a pretty compelling story. If we don't consider the customer's perspective of what the true need is, it's really hard to decipher what the indirect greenhouse gas emissions are and what the alternative is. So that, as to the timing of it, I think also that until you know what the presumed impact is, it's kind of hard to know what mitigation level is needed. So I think it might be a two-step process.
Thank you. Any other panelists want to jump in on this question? Really trying to get at, what are the opportunities for project applicants to submit mitigation proposals, considering it sounds like some folks, Mr. Vanderwalt has talked today about projects do have mitigation proposed at projects.
Well, Catherine, from an EJ perspective, I think you kind of asked me this question before about when should folks having projects talk to EJ communities. And again, I think that there needs to be a coherent plan in place that says, here are our objectives of meeting the energy needs of folks, of reducing emissions in EJ communities, of not having electricity be too costly to either produce and to buy. And so then any single project will have to fit into that plan. And so, you might say, well, this project is good because it will allow a plant in an EJ community to run less while not overburdening community where the project will be centered. Or this mitigation is good because it helps us get to where we want to, be with respect to our overall goals. And, we're not doing that now. I mean, we want an equity-centered process. I'll give you an example. The grid now does not consider equity or EJ at all, as far as I know. Right? Plants come on mainly based on it's going to be less cost. It's going to be cheapest to produce electricity. So that kind of plan is not taken into equity at all. And we think we need to have plans and strategies and a coherent program that addresses equity EJ up front.
Thank you, Dr. Sheets. Mr. Vanderwalt?
Thank you, Kat. Pursuant to NEPA process, we believe we already provide FERC with GHG impacts and consider potential mitigation factors available and applicable to the project at the time of filing. In the case of RGLNG, as I mentioned early on, we voluntarily filed a limited amendment to include which includes the use of the EPA EJ screen tool to incorporate carbon capture and storage at a further mitigant to reduce the GHG impact as originally submitted and approved by the FERC. And as I mentioned earlier on to Chairman Glick, the U.S. government has implemented a tax incentive, the 45Q program, to facilitate the use of carbon capture technologies on industrial facilities. With this incentive, we have found that it is physically and financially possible for RGLNG to implement CCS, and we hope that other projects will explore these options as well. Thank you.
Thank you, Mr. Vanderwalt. We're going to go ahead and ask another question real quick. This question, again, is about market-based mitigation measures. And so some of you touched upon this in some of your previous answers, but are market-based mitigation measures really effective and verifiable methods of mitigation over the entire life of a project? Anywhere from 20, 50, even 60 years, perhaps. What effects with this type of mitigation from commission jurisdictional projects, and mitigation both direct and indirect, have on these offset, REC, and greenhouse gas compliance markets. That's something we really haven't discussed before. Okay. Dr. Scott.
Thanks. So I certainly understand the skepticism about, being able to verify that over the life of a project, and that was certainly something that we saw, and so that's why we think that measurement is a really critical answer to this piece, and why we think that if you can actually measure this, then in fact you can verify that you've achieved those reductions through a variety of ways. And I think for this sector, that's probably going to, that's going to involve all of the pieces of conversation people have talked about here, whether that's carbon measurements, whether that's methane measurements, whether that's the measurement of other co-emitted pollutants that might be occurring in this process. And so I think the answer to are market-based measures effective and verifiable is perhaps maybe that we should ensure that they should be, and we at Project Canary think that measurement is going to be a key part of making sure that happens.
Thank you. Anyone else interested in chiming in on this particular subject? Okay, Kat, do you have any follow-up questions for the panel?
I don't have any follow-up questions, but this might be an opportunity, since we've covered a lot of ground, to just check in one more time as we're getting to the end, make sure that the chairman or the commissioners don't have any follow-up questions at this time. This might be our last opportunity to ask some of those questions. Chairman Glick?
Thank you, Kat. I don't have any follow-up questions now. Thank you, though.
Thank you. Commissioner Danley?
Nope, thank you very much.
Great. Commissioner Clement?
Thanks. I don't have questions, but I do really appreciate this conversation, and just want to, I'm intrigued by this conversation of measurement versus the credit, and the potential for some sort of certified gas product, and also, the involvement of customers in some way in process. I think these are things I'd love to hear more about in post-technical conference comments, and I certainly appreciate the concerns about trying to bake in environmental justice considerations into market-based mitigation. So thank you for sharing that as well.
And Commissioner Christie?
None, thanks.
Thank you. I'm going to turn it over to my co-moderators so that we have sped through all of our questions on this panel today, and he's going to close us out and provide some additional information.
Well, thanks. I want to thank all the panelists. Obviously, physical mitigation, as people touched on earlier, is one of those subjects that we could have a day or more on. It's one of those subjects that it's very detailed and it's very complex. And I'm sure we'll be talking about this more in the future, so I want to thank everyone for that. And I certainly want to thank Chairman Glick, Commissioners Danley, Clements, and Christie for joining us here. So this concludes panel 2. And we're going to go ahead and take a lunch break now. And we're going to return at about, what time are we going to finish it? We're going to return here. About 1:45, I believe, is what we're looking at, correct?
Correct, 1:45 for panel 3.
1:45. And with our moderators, Brandon and Alex, and some details, panel 2 panelists, please sign out of your WebEx meeting. If you would like to continue watching, you may use the public webcast link, on the conference event page at FERC. The chairman, commissioners, and panelists for panel 3 should be online by 1:35 p.m. We will run through the technical logistics at that time to make sure everyone has been able to connect. Again, I want to thank everyone for joining us today.
Good afternoon, everyone. Welcome back from lunch, and thank you for joining us for the third and final panel of today's Greenhouse Gas Mitigation Tech Conference. The first two panels have been extremely informative, and I suspect this one will be as well. My name is Brandon Hankey, and I'm from the Commission's Office of Energy Market Regulation. I'm joined by my colleague and co-moderator, Alex Zaraby, from the Commission's Office of the General Counsel. For those of you tuning in for the first time today, I wanted to cover some logistics for the conference. This will, in fact, be the last panel of the conference, and only the commissioners, panelists, and a small group of commission staff will have speaking roles this afternoon. This conference is being webcast and transcribed. And again, we remind all participants to refrain from any discussion of pending contested proceedings. If anyone engages in these kinds of discussion, a FERC staff member will interrupt to tell you to avoid that topic. With those reminders out of the way, let's begin our afternoon panel. This panel is entitled Compliance and Cost Recovery of Mitigation. The first half of the panel will cover cost recovery, and the second half will cover mitigation compliance. I'm going to call on each panelist in turn to give the response to our first question here on cost recovery. And I ask that everybody limit their responses to around 3 minutes or so. And after that time, we'll begin a short question and answer session based on our agenda, and then begin our discussion on mitigation compliance. So the first question I pose to our panelists is the following. What factors should the Commission consider if project sponsors propose to recover the cost of mitigation measures? And so first up, I'd like to hear from Stephen Mayfield, Assistant General Manager of Gas Operations at the City of Tallahassee. Go ahead, Stephen.
Thank you very much. I want to thank the Commission for hosting this technical conference and appreciate the opportunity to share my experience on this important and relevant topic. I'm Stephen Mayfield, and I've been in the natural gas industry for 22 years, all of it with the City of Tallahassee. Today, I'm speaking on behalf of the American Public Gas Association, which represents approximately 1,000 publicly owned gas systems throughout the country. Public gas systems are not driven by profit, but instead take pride in serving their customers and are part of their community. APGA supports environmental stewardship and commits to educating our membership on the best practices on emissions reductions in their operations. We are also emissions mitigation research initiatives, but understand that energy costs are very important to our customers. First and foremost, when considering greenhouse gas emissions, mitigation measures is the cost impact to consumers. APGA members operate as not-for-profits, so any additional costs are passed directly onto the bills of our communities, homes, and businesses. Energy needs to remain affordable. With the economy still recovering from the shock of the pandemic, additional costs will add to a new economic strain. Additionally, we must be conscious of low-income communities, which many of APGA members serve. They already face significant energy burdens, and increasing energy costs will just further their energy burden. According to the Department of Energy, the national average energy burden for low-income households is 8.6%. This is 3 times higher than the non-low-income households, which is estimated around 3%. In some areas, depending on location and income, energy burden can be as high as 30%. Of all U.S. households, 44%, or about 50 million households, are defined as low income. APGA understands the importance of emissions reduction and is working with its members to reduce emissions through education and sharing of best practices. We in Tallahassee have shown our commitment to emissions reduction by joining EPA's Methane Challenge program and incorporating emissions reduction best practices into our operation. Summarizing, one of the most important issues to consider on the cost of mitigation measures is the energy cost impacts to consumers. Increased energy costs will affect all consumers, but low-income households will feel the burden the deepest. Basically, those that can't afford it will feel the cost impact the most. Thanks for the opportunity to share, and I look forward to the rest of the technical conference.
Thank you, Mr. Mayfield. Next up, we have Mr. Chris Humes, Senior Vice President of Operations and Projects at TC Energy. Go ahead, Mr. Humes.
Yes, thank you. And I, too, would like to thank the Commission for the opportunity to speak here today at this conference, along with fellow panelists for an excellent discussion topic. So, similar theme, TC Energy is committed to complying with the existing and emerging regulatory requirements that will facilitate a reduction in greenhouse gas during construction and operation of our facilities. TC Energy is further evaluating additional voluntary GHG mitigations, which we're already implementing today by electrifying our fleet, reducing venting, and looking for ways to move molecules more efficiently around the U.S. We also seek to deploy, to the extent they are feasible and prudent, additional and new emerging technology as well. But notably, certain mitigation techniques, such as the transportation and greater volumes of RNG, may require regulatory flexibility from the Commission to ensure that pipeline integrity is not compromised. TC Energy also recognizes that overly costly mitigations could be counterproductive because they would raise the rates paid by pipeline customers and increase the gas prices paid at the end by users. This could result in a significant impact to low-income families, which are also most affected by price increases. In addition, downstream markets such as LDCs and electric utilities may be depending on natural gas to meet their own GHG reduction goals as well as reliability needs. Increased gas prices could harm these efforts and actually result in an increase of greenhouse gases if more GHG-intensive fuels are used in place of natural gas. In developing its approach to this topic, it will be essential for the Commission to consider these practical implications. So, thank you.
Thank you for your comments, Mr. Humes. Next up, we have Dr. Carl Peckman. Go ahead, Mr. Peckman. You're muted currently. We can't hear you.
Before. Now you can hear me?
Yes.
Okay. I apologize. It's one of these mysteries of modern technology. But I want to thank the Commission, and I appreciate all the members of the panel, and appreciate your forgiveness of my being a better regulator than I am a technocrat in terms of running this equipment. The answer to the question, I think, is it depends. And what I mean by that is that there are different kinds of regulatory relationships that the FERC oversees. It oversees market-based relationships and cost of service types of relationships. And to the extent that that mitigation measures are undertaken in a market-based context, it seems to me that those should not be recoverable in rates. Those would be recoverable in costs or in prices to customers, to the extent that the firm has a competitive advantage in terms of selling those items. With respect to regulated rates, which is obviously an issue at the state level as well, it really depends on whether or not the investments are prudent, whether or not they're least cost. And I think there are a whole bunch of issues associated with that we can get into in response to the second question. So the answer is it really depends upon the regulatory structure under which investments in operation of the gas facilities are being undertaken. Thank you.
Great. Thank you, Dr. Peckman. Next up, we have Honorable Diane X. Berman.
Great. Thank you so much. I really appreciate being here. Just sort of, first I want to thank the commissioners and FERC staff for putting this together. I am glad, I realize I'm the only state commission regulator that is speaking at this technical conference today, so I appreciate that opportunity. I am just back at work. Yesterday was my first day back at work after having some minor brain surgery. I was thinking of canceling because of that, but I realized just how important this conversation is. So I'm really glad that I'm able to be a part of it. We already heard today a lot of the critical issues that I think factors into now where we are, at least where I sit as a New York State regulator. We heard on panel one the level of mitigation for proposed projects reasonably foreseeable greenhouse gas emissions. New York State has passed the Climate Leadership and Community Protection Act. This act requires that greenhouse gas emissions be reduced statewide 85% from 1990 levels by 2050. Many people misinterpret that law and other activities as that New York is anti-gas, and that based on that law, we must get rid of gas dramatically. That is actually not actually accurate. We need to continue to find ways to work together in reducing greenhouse gas emissions, but we cannot do that, especially as we move forward with our critical clean energy initiatives, without ensuring that we are uncompromising in our focus on the need for a safe and reliable system. And that has to be prioritized, and we need to work together on that. We need to provide ways that we're showing the value of natural gas and reducing greenhouse gas emissions. Industry is already showing many successful activities. States are also showing many successful activities in this. And we need to work together to develop fuels like renewable natural gas or hydrogen, carbon capture technology, and other things that will make the product less carbon intensive. And we can work together on that. My threshold question is, why is it that we think that FERC can do this better than the states are already doing it, industry is already doing it, and we see just even from the federal EAP announcing on November 2nd that it's taking action to reduce 41 million tons of methane emissions from 2023 to 2035. And in 2030 alone, the rule would reduce methane emissions from sources covered in the proposal by 74% compared to 2005. And it actually lays out in there looking at states developing plans to limit methane emissions. Many of the steps outlined by the EPA are already included in New York's Climate Leadership and Community Protection Act, already being done in New York in many different aspects. And so I would push back a little bit and say, I do think we have to take a look at the threshold legal issue and make sure that we are not trying to encourage barriers to what we're already doing, but rather see how we can work better. Perhaps the FERC Commission would certainly obviously need periodic reporting from project sponsors to monitor and assess mitigation during the project life. Many of that can already be done in some of the things that we're looking at, reporting in Section 4 rate filings, for example, a notice of proposed rulemaking. Stakeholders should be consulted on how much measures may impact them, including any costs associated. In addition, the EPA is already providing for some reporting or evaluation of greenhouse gas emissions. New York, through our DEC, Department of Environmental Conservation, is already looking at that. We have another agency that's looking at methane reporting. And so I would say that FERC perhaps can do a better job of working with the states and the industry to make sure that we are giving you the information that you feel you need in what we're already doing, and help us in being successful in continuing our activities from that. Look forward to further discussion on that. Do note that, we even just saw from panel 2 just the detail in some of the specific technologies that are out there and projects that are out there. DOE and PHMSA are engaged in a lot of that, as well as EPA. New York has been focused on residential methane detectors, leakage surveys, and a whole host of other things. We even saw, excitingly, an interstate pipeline operating in New York that offered up a potential mitigation method, such as transfer compression technology to capture methane releases, vent recovery systems to capture methane releases, catalysts to drastically reduce CO emissions, and routine, more than once a year, leak detection and repair, and the list goes on. I would encourage us to work together to make sure that we're collaborating in a way that doesn't present unnecessary barriers, does not increase pressure on the customer bills. FERC should be very concerned about the end-use customers and users and the cost that may get imposed on that. So I look forward to working together. Thank you.
Thank you, Commissioner Berman, and we really do appreciate you being able to come out today and offer your insights. Next up, we have Ms. Rachel Dawn Davis, Public Policy and Justice Organizer at Water Spirit.
Okay, great. Can everyone hear me? Great. Greetings for commissioners, staff, and all those watching, and thank you for the opportunity and invitation to participate in this conference. In my role with Water Spirit, a ministry of the Sisters of St. Joseph of Peace, I hope today to bring the moral voice of people of faith across Turtle Island and our collective obligation to protect all creation for young people and future generations. I linked as a student the perpetuation of oil and gas and war, incessant flows of veterans coming home with post-traumatic stress, preventable physical ailments, and other measurable social costs, with the potential for a better path, investments in renewable energy, localized energy economies, a greener, regenerative planet for all. To begin, we must consider all projects from cradle to grave. Methane, which is significantly more potent of a greenhouse gas than carbon, as you heard earlier today, exacerbates climate change. Hydrogen prolongs methane emissions in the air, and all of it adds to cumulative taxpayer costs attributed to increased frequency of fire, flood damage, cost recuperation throughout the land. Climate change is expensive. We need to strive for real zero. Friends of the Earth's Chasing Carbon Unicorns report shares governments and other actors should set two distinct targets to phase out use of fossil fuels and invest in and support ecosystems and the people and livelihoods dependent on those ecosystems. First and foremost, they must adopt an emissions reduction target that leads to real zero. So if project sponsors propose to recover the costs of mitigation measures, FERC should consider various factors. A few of them are time and technology, fugitive emissions, transparency of data, and project sponsors as beneficiaries of perpetuated carbon industries. Air and water know no bounds. Their contamination is irreversible, and public knowledge and outcry have demonstrated a need for climate emergency declaration. FLIR cameras and GIS technologies exist, and other technologies you heard about before, to capture the data, and there are some key studies out and about, one in particular in Pennsylvania, connected to the Delaware River Basin with respect to methane emissions reports there. Colorado also was spoken about today. Indirectly, directly, and cumulatively, emissions must be considered. Dr. Sandra Steingraber pointed out recently, in response to the new methane rules, that they will not regulate methane emissions from abandoned wells, which is huge and may exceed leaks from productive wells in basins like the Marcellus, nor does it cover malfunctions in gas flaring, which are a big source of extreme methane plumes in the Permian. Transparency has afforded the growing younger generation that polluting companies have done so knowing full well the havoc it would wreak on our life support systems on Earth, not to mention the grid in Texas. So independent ownership of all emissions monitoring technology and emissions data collection is necessary. There's an example of UC Davis, their Air Quality Monitoring Research Center, because it is focusing on real-time data and the community can contribute to that data. It's trusted. And finally, CCS and other technologies not possible of being proven to function and not financially proving viable where it exists, leave workers lost. We must protect workers and their future and families. FERC should do due diligence. These carbon schemes are false solutions, and we should be doing better for our children by preventing emissions as quickly as possible and investing in job training programs for transitioning workers into a green economy. Thank you for this opportunity, and I look forward to this dialogue.
Thank you, Ms. Davis, and to the rest of our panelists as well. At this time, I want to give the chairman and the commissioners an opportunity to respond to that first question or ask any questions if they have any. So first up, Chairman Glick, would you like to comment?
Thanks, Brandon. Can you hear me?
Yep, loud and clear.
Okay, great, thanks. Actually, I just wanted to pick up on what Ms. Davis said at the end there about carbon capture and sequestration. I wonder if you could elaborate a little bit on your concerns that might not be a sufficient mitigation tool.
Yeah, sure. I don't think that it's possible to prove that that carbon can be stored for 1,000 years. And so, that being said, in of itself, right there, it's very skeptical. I know Dr. Sheets mentioned this on the last panel. We're not very much, we are going to remain skeptical and scrutinous of technologies like this that really do not have the research backing it up. And I would recommend that you check out research that is going on about this, more than I could ever share with you in detail, but from Food and Water Watch. It's a great organization independently researching all of this. So yeah, we're very concerned. This is, as Dr. Sheets said, this is the time now. That's what we have. So we are really focusing on solutions that we believe will have the best outcome possible, knowing all the knowns we know.
Does anyone else want to comment about carbon capture and sequestration as a mitigation tool? Hand up.
I would actually like to comment about carbon capture and storage as a mitigation tool, if that's okay. My name is Paula Van Lanningham. I am the Global Head of Carbon at S&P Global Platts. For those of you who are unfamiliar with the organization, we are a price reporting agency. So my specific role is looking at voluntary and compliance markets, as well as a lot of the development around carbon mitigation and carbon accounting pricing that is probably going to start playing an increasing role in this. So one of the things that we have been looking at quite a lot is the effects of carbon capture and storage. I do think it's perhaps a little premature and perhaps counterproductive to claim that carbon capture and storage is never going to be a solution to the emissions problem. This is an area that is actively being improved and developed quite regularly now, and there are a number of different ways to do that, both naturally, but then also in improved technologies. One of the things that I draw attention to for folks on the panel is, of course, the speed at which we've been able to scale up renewable energy over the last 10 years and make it one of the cheaper ways to receive energy. That sort of technological advancement is something that is distinctly possible with carbon capture and storage. I do think that we agree, and certainly a lot of the market participants that we speak to on a regular basis agree, that it's never going to be the single one solution to any sort of climate change problem. It cannot be the thing that everybody is like, oh, well, we can continue to emit at our current levels and not use carbon capture and storage. But if we have any hope of meeting the Paris Climate Agreement goal of 2 degrees, let alone 1.5 degrees, this needs to be part of the solution somewhere down the line. So it does need to be kind of considered part of the overall conversation. And I think that it is, and I think that the carbon capture technologies that you see now are not the carbon capture technologies that you will see in 5 years or 10 years. This is something that is really, really evolving very rapidly and will continue to do so moving forward.
And thank you. This is Commissioner Berman. I'd like to address that too. I think it's really important. Sometimes I wonder about why people are anti-renewable natural gas, hydrogen, or carbon capture. This is an all-hands-on-deck approach, and as far as I'm concerned, we should be putting as much focus on innovation and technology as we can in all areas to be able to help us. It's becoming more and more common to see operators employ gas capturing techniques so that little or no gas needs to be purged to the atmosphere during maintenance activities. These pump-down technologies allow upwards of 90% of the gas to be captured and re-injected into the pipelines rather than emitted into the atmosphere during pipeline operations and maintenance activities. Why wouldn't we want to explore that? Why wouldn't we want to lean in? If we did that, if we said no to so much of what we're saying in the solar field, energy storage on the electric side, we wouldn't have gotten where we are and continue to get. All areas of what we're doing in the energy space should be looked at. I mean, we're even seeing, and I know you can't speak to it, but Rio Grande LNG just filed an application to add carbon capture to their projects to help mitigate greenhouse gas emissions. How amazing would that be if, as their plan says, it would be able to trim emissions at least 90% from earlier proposals? I think that's wonderful. Carbon capture and storage play an important role. We just saw in the news, I think, today in the latest Gulf lease auction. All of these things are not about continuing the same old way. It's about really innovating for new solutions and helping all of us. So I say, let's figure out a way for all of us to collaborate together, to break down the barriers, and figure out how we can enable the industry to continue doing activities to help increase successes that benefit all of us and ensure that we are still maintaining our focus on safety, reliability, and keeping the costs down. NERC's latest study is one that I say we need to be worried about, because if we're worrying about what this winter is, that's a real problem for us, and we should be doing all we can to make sure that we're keeping the energy grid as reliable as it can be. Thank you.
And just to add to this discussion, I think CO2 sequestration is actually a great tool that we should utilize. We have been injecting CO2 for probably 50 years, and so there is a big data set there and a lot of information that we can get smarter tomorrow from. I do agree that new technology will come and we will get better at it. These are very expensive wells to drill, but it's because they're very robust. You have several layers of steel with concrete all the way to the surface, and so these are very robust wells. These are not the wells that we initially ejected CO2 in 50 years ago. I think to the point that it can be there for thousands of years, I think a good example is Sheep Mountain, Colorado. There are huge reserves of CO2 that have been there for millions of years. Traditionally, that was piped down to a 24-inch CO2 pipeline to the Permian Basin to inject for tertiary recovery. I think it proves that CO2 can stay in the ground for millions and millions of years without making its way back to the surface, as it has in that case. I also agree with my panelist, Diane. I think there are a lot of things that we can do to improve. I love the capture technology. I think that's some low-hanging fruit that we can do that doesn't add a lot of cost. And I think there's other things we can do to get more efficient about moving gas around the U.S. efficiently, which will help us reduce costs of natural gas, which makes it easier for the most economically challenged in the U.S. to heat their homes, so they don't have to make a choice of putting food on the table and heating their homes. We can get more efficient, we can reduce venting, and we can electrify our fleet so that as the grid gets greener, the compression we're using to move natural gas around will get greener as well. So thank you for your time.
And just keep in mind, the question also is, what does FERC actually need to address and get involved in? And so if you are looking at it, one of the questions should be on what are you currently doing, but also what is already going on in your federal sister agencies, in the states, and out there that you can actually maybe help in being a partner in. Doesn't mean you need to get into the weeds, doesn't mean you need to do anything other than make sure that you're getting the information that you need to feel comfortable.
Well, I believe that there's not a one-egg-fits-all solution to this. And what we need to do is we need to attack it in all areas. And I agree very much with what Commissioner Berman said, that we need to ensure that whatever we do, we maintain a safe and reliable energy system. I believe that's very important. APGA feels it's important for all methods, so we fund a lot of research in the areas that improve appliance efficiency, which is a downstream use of energy. And we also work to fund carbon capture and renewable natural gas and other methods that are helping reduce emissions. So I think it's going to take all of us working together and looking at all modes and means in order to accomplish this goal of reducing emissions globally.
Thank you, everybody. I wanted to give the other commissioners a chance to speak up if they choose to do so. Commissioner Danley, do you have any comments at this time?
No, thank you.
Commissioner Clements?
Thanks, Brandon. Commissioner Berman, thank you, first of all, for being here today, and I wish you continuing recovery all the best. And appreciating your admonition around, what other agencies are doing, what the states do, relative to the Commission's jurisdiction over interstate pipeline rates and approval. Do you have thoughts on how we should think about costs related to potential mitigation? Should we land in that place, and how the Commission might think about it, how you have thought about it, or other states think about it?
So thank you for the question. I appreciate it. So what I would say is New York State regularly takes part in negotiations on interstate pipeline rate cases at FERC. It's no secret that New York State has historically advocated routinely for lower rates of return than FERC has traditionally awarded to interstate pipelines. NARUC actually did some work on a controversial resolution a while ago, talking on getting more collaboration on dealing with that issue. Personally, I think that was a good opportunity for me to see just how contentious things can be, but also how much it's really important that people do their homework and know what's actually going on, and then ways of helping to engage on a tough issue, bring people together, and better ways to handle it. The impacts to end-use customers has to be a priority for FERC. Pipelines have to be able to be allowed to demonstrate that it's incurring unusual and unplanned expenditures, especially as the result of some governmental action which cannot be avoided. Surcharge mechanisms can reduce the risk of cost recovery. Obviously, you have to also look at what does that mean in terms of a return on equity and go through that. From my perspective, I think it's also important to just take a step back and just to kind of focus on where it is helpful to push things in a way that can help us foundationally. I do think that the legal jurisdictional issues are a challenge for you. I know that there's a lot of different opinion for whether FERC has the authority to mitigate. I raise that not because I'm also a lawyer by trade, but also because that threshold issue is something that needs to be addressed. Legal uncertainty is going to be a problem. I think it's best to collaborate and be reasonable. Work with the industry, work with your other agency, federal agencies, as well as state partners to support activities. PHMSA is having at the end of November a technology two-day conference looking at ways to be able to be environmentally friendly as well as reliability and safety. Let's help us all show true successes. Do not try to get in the weeds in something that is actually going to not bring us forward. I do think you need to get to 5-0 solutions on these issues. They're very contentious. It's not just about, listen, I've been on the commission since 2013. I was a staffer before. The best solutions are the ones where you can come to reasonable grounds. Set out some framework, be responsive, be responsible, but having myself been a commissioner where I've had some chairs who have said they want to have, if they can, everybody buying in. It's only buying in a 5-0 solutions now. My commission just went to 7, so it would be 7-0. Sometimes those only happen if everybody is willing to realize that their position may need to be looked at a little differently and figure out alternatives and solutions. But it's not just about, if you agree with us, jump on. If you don't agree with us, we're going to go 3-2. It's not going to work. I don't want us to be in litigation of these issues. It's too important for us to figure out ways to adopt technologies and to move forward in pushing and ensuring we're all properly evaluating greenhouse gas emissions from natural gas. So.
Thank you, Chairman, Commissioners, and panelists for expanding on that question. I did want to move on to our supplemental question where we open the floor, and I can let you guys answer by using the raise hand function. So the next question we have is, would allowing recovery of market-based mitigation measures, for example, the purchase of offsets, through an annual tracker or a surcharge be appropriate? Mr. Mayfield, I believe you were first.
I must be a little quicker than I thought I was. Thanks for this question. The most important thing is energy needs to remain affordable, and I think there are many best practices that can be instituted before the fallback of purchasing offsets. If best industry emissions management practices are followed, then the need for offset purchases will be greatly lessened or even eliminated. I'm a little concerned about how market-based mitigation measures such as the purchase of offsets may be used. While they can be effective tools to offset emissions of an organization's striving to net out its emissions, I'm concerned in this case that low-income or economic justice communities may have to bear the increased energy costs, and I've heard that mentioned several times through this panel by other members. As the Commission continues to explore this potential avenue, a balance of cost and regional environmental benefits should be front of mind. Thank you.
Dr. Peckman, if you'd like to expand on this.
Thank you. I think the answer is that that market-based mitigation measures are a positive contribution and allow the reduction of greenhouse gas measures in a more efficient manner and help to reduce the cost of meeting particular targets. Having said that, I think that the FERC has a unique role to play with respect to the coherence of market-based mitigation measures. And in particular, many of those measures are now voluntary. There are a couple of places in the United States, like California, which are establishing rules. But it seems to me that there needs to be a set of rules. And coming from the regulatory side, the Commission has really created coherence in a lot of different kinds of markets. It did so by creating accounting techniques in the 30s. I'll go through the whole list in my comments, but or at least a longer list of my comments. But the point that I'm making is that it would be very helpful if you're using market-based tools to have a standard and to have verification that what customers are paying for is actually real. So, thank you.
Thank you, Dr. Peckman. I believe Commissioner Berman, your hand was up next.
Oh, thank you so much. So I'm just having a little trouble understanding the offset issue. So given that projects such as interstate pipelines don't sell natural gas and consume very little during the course of their operations, it's hard for me to imagine how offsets would be useful. It's hard for me to imagine that there'd be enough to go around, and it's hard for me to imagine that the price would not skyrocket significantly. If they were to employ such strategies, it seems to me that the costs could be minimal, although the costs should probably be recovered from shippers. So the concern is that, for me, that a pipeline purchasing offsets, passing these costs on to the shipper, who then collecting those costs from the retail customers while also collecting costs from mitigation measures of their own. So I just want to make sure that we're ensuring that retail customers are not paying twice for the same mitigation measures. For example, in New York, we have a methane reduction plan, which is sponsored by our environmental agency, our Regulatory Research and Development Authority, our Ag and Market, Soil and Water Conservation Committee, and as well as our Department of Public Service, which is the staff arm of the Public Service Commission. So if a pipeline should not have to charge for mitigation, so I don't think a pipeline should have to charge for mitigation on top of that. Some end-use customers, as indicated, also have to employ mitigation measures. They have to report that on emissions. So this could just compound the problem even more for those retail customers. To the extent that FERC needs to be satisfied itself that measures taken by pipelines to reduce or eliminate greenhouse gas emissions are not duplicative, I understand that. We need to also make sure that we're looking at appropriate things. Maybe we need to lean in a little bit more to help show what we're doing in our state, in other states, and what the activities are already being done. As I said, I do think a tracker or surcharge mechanism may be helpful. We need to work through some of those challenges. But as to the offsets, I just get really a little concerned about that. So,
thank you. Ms. Van Lanagan. You're muted.
Sorry, so just a bit of background. I am based on London, which is both why it's dark, and also apologies if I say methane accidentally during this conversation rather than methane. But I mention that because based over here, one of the things that the carbon compliance market has done within Europe has done a very effective job of driving down emissions from power generation. And while I don't necessarily expect there to suddenly be a EU-based style client-based allocation market that develops in the US the same way, one of the things that it does demonstrate is that the additional costs associated with market-based measures can have a significant impact on driving down overall emissions over time. There are different ways that people understand voluntary carbon markets in particular, and I assume that's what people are referring to in lieu of offsets in this concept. And Commissioner Berman's point about how there might not be enough to go around and how the price would potentially skyrocket is a big part of the reason why any potential solution to this problem would also include substantial investment in overall pipeline infrastructure as well as natural gas infrastructure to cut down on the overall emissions profile. There's no way necessarily to guarantee that at least some of that cost is not passed down to consumers, but that it is important that market-based solutions are explored as a potential opportunity because they really are quite effective at cutting down on the overall emissions profile more generally. Voluntary carbon markets in particular are often quite misunderstood. There has been a lot of development in that space, particularly just in the last 2 weeks, as well, in order to bring additional kind of sort of understanding and credibility to the fact that those projects actually bring real emission savings, but they need to be, but they are a pretty important part of the overall conversation because you're going to be able to pull emissions down to zero. So at a certain point, you need to start employing some other base market measure to sort of help bring that.
Thank you. And I want to give Mr. Humes and one more person maybe the opportunity to speak quickly to this because I saw your hands raised, Ms. Don Davis. However, we do have to move on to the mitigation verification, so if you guys could manage to keep it relatively brief, that would be great.
Yes, thank you, moderator. I'm not an expert on market-based mitigation measures, but what I can speak to are the things we're already proactively doing to reduce our emissions. Currently, we're electrifying the fleet, we're reducing our venting, and getting more efficient about moving molecules around. And by doing these things, we're able to successfully reduce our greenhouse gas emissions, and that's why we were able to announce last month that we're going to reduce our emissions by 30% by 2030 and get to net zero by 2050. And also by doing these things, we can keep our costs down so that the most economically disadvantaged Americans can have cheap, affordable, and reliable natural gas. I would like to point out that during the polar vortex, we set record delivery of natural gas to people so that they could heat their homes and so the electricity could stay on in the U.S. And so, I think that speaks to the value that natural gas provides. Many people in their GHG programs to reduce emissions have natural gas as part of their toolbox to reach their greenhouse gas reduction goals. Thank you.
Ms. Don Davis, did you want to say something quickly?
Yeah, sure. And I'll lower my hand. Just really quickly, again, I'm echoing Dr. Sheets regarding offsets and agree with my fellow panelists that it might not be the best option. Our coalition partners in water sport, we don't believe in market-based activities that those will result in the change necessary to meet our challenge, as we should have worked on this really for decades earlier right now. So my question really would be, maybe the better question is, why do the project sponsors have to recover costs of mitigation? There should be no cost recovery for project sponsors. The harm inflicted is the reason to offset the harm through the mitigation. And, with respect to retail customers and reliability, absolutely, we are all together in need of realizing how unreliable natural gas has been, specifically in Texas, and that we should aim to innovate to stop polluting in the first place and not use low-income people to scare this panel into letting polluters keep polluting. It's the logic of abuse. Thank you.
Thank you. Mr. Pegman, do you have your hand raised? Did you want to say something very quickly before we move on to Mr. Zarabi's questioning?
Very quickly, I just wanted to follow up on Commissioner Berman's issue of double counting. a standardized accounting and certification system of offsets would mitigate that, if you will. And in particular, California has, in their offset requirements, has the requirement that an offset be proven to be additional. Thank you.
All right, that seems like a great stopping point. So thank you, panelists. With that, I now turn it over to my colleague and co-moderator, Mr. Zarabi, to commence our questions related to compliance and verification. Go ahead, Mr. Zarabi.
Thanks, Brandon. As we have with the other panels, we'll start with an introductory question to all the panelists, and I'll call on everybody in turn, and we ask just to limit the responses to about 3 minutes. So our question for compliance is, how could the Commission ensure continued verification and accounting of GHG mitigation measures, and what are the challenges the Commission should consider when setting up a compliance program? And we'll start with Mr. Mayfield.
Thank you. Again, I'd like to thank the Commission for hosting this discussion and allowing us the opportunity to provide input. The Environmental Protection Agency is already tasked with accounting for greenhouse gas emissions on an annual basis. It's important for the Commission to consider not duplicating efforts from other agencies. This would just add an unnecessary burden by wasting resources of both the project sponsors and the regulatory agencies. Coordination with EPA, who would likely be the agency with jurisdiction over post-construction emissions, or a state counterpart, is the most efficient way to monitor mitigation during the life of the project. One of the most significant challenges for a compliance program is measurements of greenhouse gas emissions. Greenhouse gas reporting does not measure actual emissions of greenhouse gases, but instead uses calculations provided by the agency, which are based on length of pipe and number of meters, regardless of whether methane is being emitted. While we do use equipment in the field to locate and pinpoint leaks, false positives do occur as methane is naturally occurring from other sources. If FERC does choose to allow a project sponsor to recover the cost of mitigation measures, verifying successes of one of those measures is crucial. Since measuring greenhouse gas emissions is difficult, validation of a compliance program could become costly. These costs would ultimately be passed down to consumers, which would increase their energy burden, which is already significant for low-income communities. Accordingly, the Commission must be especially diligent with compliance to ensure the costs are worth it. Basically, FERC should ensure cost increases due to mitigation efforts must result directly in consumer benefits through verifiable emissions reductions. In lieu of an actual measurements, another way to approach the compliance verification issue is for the Commission to incentivize the adoption of prescribed best practices. The Environmental Protection Agency has a natural gas star methane challenge program, which has a best management practice commitment option. Susan Waltzer discussed this program on the last panel. This program focuses on implementing demonstrated commercially available emission-reducing technologies and best management practices. As technological advances occur, it may become more cost-effective to accurately measure emissions. APGA helps to find technological advancements through its association with the Gas Technology Institute. GTI works to improve appliance efficiency and reduce emissions. Through our partnership with GTI, we are helping to develop better ways to measure emissions that can be used in a compliance program. The major takeaway is not to make the reporting and compliance in generally overly burdensome to project sponsors or duplicative of other federal agencies' work. Sharing and implementation of best management practices with consumer cost in mind will reduce emissions while minimizing increases to energy burdens on those of the lowest income level. Thank you.
Thank you, Mr. Mayfield. I will turn it over to Mr. Humes now.
Thank you, moderator. Similar comment as my previous panelists. We, as part of our permits, we already have to report greenhouse gas emissions to the EPA FERC could receive this information from the EPA as a way to monitor emissions as well as the effectiveness of our mitigation measures. And so I'll just end it there.
Thank you. Dr. Peckman?
Yes, I appreciate the reporting to EPA, and also I would suggest that probably state environmental regulatory agencies as well. I will come back to the idea that there are both the physical mitigation on projects, but there are the offsets on projects. And to that, I'll come back and say that there has to be an ongoing system of measurement and verification to make sure that what customers are paying for is real. Otherwise, it would be difficult to say that the purchase of those offsets is just and reasonable. Thank you.
Thank you. Commissioner Berman?
Thank you. I especially liked the mention of One Future as a possibility for how we're doing methods for calculating low methane emissions intensity. We also have natural gas sustainability initiatives that the AGA and EEI built off of on the One Future, creating a technical methane intensity protocol. And GTI and others are doing a lot in that space, also developing to try to develop more accurate, transparent tools for calculating measurement-informed methane emission intensities for natural gas operations. I say kudos to all of that, and we should figure out ways to continue that good work and build on it with the goal of improving the accuracy and acceptance of looking at ways to report. For us, we need certainty. As a regulator, we need certainty in the accuracy of the reporting, and we need certainty that it is helpful. There are already certain reporting activities that pipeline operators must currently perform associated with their greenhouse gas emissions. Some involve reporting to the EPA, others to, like in New York, or state environmental protection agencies. Perhaps FERC should first inventory those reporting activities, determine if it can be useful for a compliance program. That would be a really great way to help with additional cost to a pipeline to prove compliance to FERC. If FERC determines that the otherwise already required reporting will not be useful, and also looks at voluntary activities and sees that they don't need to be increased, or if for some reason you say, nope, this isn't helpful, maybe hold a technical conference asking stakeholders how compliance, even voluntary compliance, can be determined. Perhaps it should be done, though, after requiring FERC staff to set forth one or more possible scenarios to receive specific comments on. I do have to reiterate that many of the steps outlined by the EPA in its most recent ongoing activities are included already in New York's Climate Leadership and Community Protection Act, especially attention to vulnerable or disadvantaged communities. So given that information, it seemed that the amount of mitigation FERC needs to require for a proposed project has been or can be addressed by the EPA or is already being addressed by New York. So please don't take that as a way for just codify what we're doing in New York. We don't necessarily have all the answers or solutions. We're still struggling ourselves. Even after the Climate Leadership and Community Protection Act was there, a lot of misinterpretation on how to do it. We're grappling with that. But we did see backlash when customers were not able to get the energy that they needed, when there were some moratoriums in our downstate, and the reliability of the system was called into question. To me, the real issue, therefore, becomes what is, how, and when the necessary improvements need to be made. What are the costs for those necessary improvements? And how can we do this in a way that is helpful to our forward progress? A proposed project should meet standards through design elements that may include the use of, for example, electric compressor units, capturing methane during any non-emergency blowdown, as well as employing best practices such as stationary and remote monitoring of emissions. But it should be done in a way that is showing that we are innovating and we are focused on really creative solutions. FERC shouldn't act in a vacuum, just like a state regulator should not act in a vacuum. And we should find a way to keep FERC apprised of our activities, not just in the industry, but at the state level, state regulatory level, relating to reducing greenhouse gas emissions. We should share best practices among the states. That would be great. and maybe all ratepayers would actually benefit from cooperative efforts rather than what sometimes appears as disjointed solutions. So thank you.
Thank you. Ms. Van Lanningham?
Absolutely, thank you. It's not necessarily our position to give a full recommendation to FERC about what the correct process would be on here. We don't really have a bone to pick in this fight. What I will say, however, is that a lot of the work that we have done in measuring on-the-ground carbon intensity in oil and gas production in the U.S. has shown that the current EPA reporting measures, which are self-reported and based very much on estimates, are not necessarily fully accurate in terms of, and that's in many cases a bit of an understatement, in terms of the level of emissions that are actually generated. So if there is any actual desire to really manage and to really reduce overall emissions, you need that accurate count in order to be able to do that. And that is sort of looking at this approach towards continuous monitoring and employing additional technological solutions to the monitoring process in order to get an accurate picture of how that works. Again, it can go both ways. It can go as an over-reporting, it can go as an under-reporting, but regardless of what it is, it's not necessarily a fully accurate picture when you compare that to overland satellite data, data from actual well monitoring systems, et cetera. So there needs to be some sort of consideration about that kind of difference between the level of reporting that we have now and the level of reporting that we have. So I'll just leave it at that.
Thank you. And Ms. Davis?
Yes, thank you. FERC could deliberately choose to focus on approving renewable energy projects and avoid further emissions that necessitate such accounting. FERC should focus on independent verification, as has been mentioned earlier, and community support of real-time monitoring. A community-driven and run program would be best suited to accurately account for toxic emissions due to the need for the public trust. The challenges FERC should consider are, again, I'm going to bring broad things, the known history of polluters, interagency communications or lack thereof, and the integrity of the Commission in this role of setting up such a compliance program, which I know was also mentioned this morning. Infrastructure supporting the industry of transporting dirty energy is inherently intermingled with those making laws regulating the same. We all know emissions from Department of Defense operations have not been accounted for since 1997. Our failure to study and prevent emissions has caused undue preventable harm of mass proportions and a lag in innovation. May we focus on trust and honesty that meets the urgency of our shared climate emergency. With respect to interagency communications, WaterSphere actually met with the Treasury Department earlier this year in coalition to understand more about the executive order on climate-related financial risk. The Treasury Department people with whom we met said essentially, we're not the regulators. There's no time for pointing fingers, however. If you're tasked with regulating an industry, there ideally should be a standard by which projects are handled and a process that takes place, beginning with the establishment of needs. Reasonable cost-benefit analyses that not only includes but prioritizes the social costs as a filter would be preferred. And if the project is not necessary, it should not take place. If there's a renewable energy option, which we're seeing more is viable in New Jersey, where I zoom in from, it should be considered. And public trust is really the challenge here, and I appreciate the mention of stakeholder engagement. The perception of FERC as a legitimate body moving forward is a challenge. FERC is famously known as the regulators that deregulate. FERC has been recently called a rubber stamp and featured last month on HBO's Last Week Tonight, demonstrating how easily pipeline projects are approved when electric transmission projects must experience more of a Byzantine conduit to get approval. So from where I sit, in the past decade, I've seen two national coalitions propose to work with FERC and try to make it better. One recently asked for FERC to become FREC, to become the Federal Renewable Energy Commission, and the other, Voices, Victory over Infrastructure, Clean Energy Instead, is continuing to educate communities about how to protect themselves through intervention, protecting their own land and their property. There's a ton of political will for this. In fact, earlier this year, Congressman Raskin and Congresswoman Barragan helped Voices lead a briefing in May, and I'll share this with you, on the abuses of FERC and needed reforms. Representative Raskin summed it up in his opening at the briefing, which is an hour long, by saying, of the 1,021 certificate requests FERC got between 1999 and 2020, it rejected only 6 of them. It is almost impossible for one of the natural gas companies to lose before FERC, end quote. We therefore applaud you and encourage FERC to keep open comments and dialogue with public and experts alike who are proposing alternative energy when new projects are announced or in need of upgrades and reliable technology that is providing helpful as we grapple with existing emissions accounting. In summary, we need independent, community-driven support through these mitigation and compliance procedures.
Thank you. I see we have a couple of panelists with their hands raised, but I'd like to give the chairman and commissioners an opportunity to respond first. Chairman Glenn?
Thanks. I'm interested in hearing from the panelists, and my colleagues might have some questions, but I'd rather turn it back to the panelists. This is a good discussion.
Commissioner Danley?
No, thank you.
Commissioner Clement?
I'm fine too, thank you.
Okay. Mr. Humes, I believe you had your hand raised first.
Yes, thank you, moderator. I guess first of all, just to comment on the FERC being a rubber stamp, I assure you that it takes over 3 years now to get a pipeline project approved. I've waited almost 10 years on some projects and not received a certificate, so I would say that does not reach the definition of rubber stamping projects. But I do appreciate the process and that we go through. I think more back to the EPA and how air permitting is done. I think what people should appreciate is what the EPA looks at when they give you an air permit is best available compression technology. So just what you did the year before to get your air permit may not get you a permit the following year. You have to use the best available combustion technology. There are some SIMS permits, which is continuous emission monitoring. That's that's a bit of a Cadillac type permit. But even the ones the other ones that they issue, you have to do a stack testing analysis. It's a very highly technical trailer equipment that comes out. You put a pitot tube into the exhaust of the unit, and you have to measure the emissions. And that's how they that's the checks and balances to make sure that you are abiding by the best available combustion technology. So EPA has some very smart people. They do their job very well, and I think that they should be given the credit that they deserve for the professionals that work there and the way they approach their job. Thank you. And I guess the only other thing I'd like to point out is, the U.S. has reduced emissions by significant amounts, and it is due to the natural, moving fuels, moving us away from coal to natural gas, and that is we're one of the few nations who have actually reduced our emissions because of that.
Thanks. Mr. Mayfield, I believe you're next.
Yes, I just want to comment on something Commissioner Berman said. She talked about the One Future, and I've looked at the One Future, and I've looked at the Natural Gas Star program. And, I know you can't see it here, but it's a nice book. If you go to EPA's website and download it, it shows you ways that compressor stations, transmission companies, and distribution companies, all different areas where they can reduce their emissions. And through these three panels, I've heard the ideas mentioned in this through a variety of ways, and we've taken every way that's listed in here for our system and are trying to incorporate that throughout. And I believe that's a great thing that all the companies can do, is share instead of reinventing the wheel, share the best practices that others have already done to reduce their emissions, and then it's going to definitely decrease the emissions and make this issue not near as relevant as it is.
Thank you. Commissioner Berman?
Yeah, so I do just want to respond. My focus especially when I hear, sort of shots at any regulatory entity in FERC is one that I really kind of bristle at. We work really hard at the state regulatory level as well as at the FERC level. And from my perspective, I really want us to be collaborating together. In my state, we have 7 commissioners now. I want us to get to as many 7-0 solutions as possible, because that means the diversity of all of us on our commission have helped. And I'd like to work with FERC to get to as many 5-0 without it being a default 5-0 positions as possible. I think it's really, really important. There has been a lot of focus on the permitting process, and we do need to address how to enable proper engagement on that issue. It's not just, and I understand the sensitivity that historically there were very few permits that were denied. I'd actually think it's an apples to oranges comparison, though, because the current ones that wind up coming before FERC may actually be the best ones because it's pretty brave of people to try to move forward on things with a lot of the other focus and all the different things that have been done or are continuing to be done. So I don't know that we could look at it from that same perspective. So we should be looking at how can we effectively work together in enabling a robust permitting review process that makes everyone feel comfortable in what they're doing. And that's where, for me, FERC can be a partner in working with us in looking at what's being done already and what they can feel comfortable that we've got it and we're doing well, and that they don't need to incorporate more in the weed stuff and things that may actually detract us from ultimately what we need to do to being comfortable with maintaining a focus on safe and reliable systems. Thank you.
Thank you. And we'll get to Ms. Van Lanningham next, but I just want to throw, one more concept, and I think Commissioner Berman and others have touched on it, but, are there federal or state agencies that monitor GHG emission mitigation measures, and how can the Commission potentially explore partnerships or memorandums of understanding with other potential federal agencies for GHG compliance? Ms. Van Lanningham?
I've been told I'm very soft, so I'll try and speak directly into the microphone on this one. But just a quick comment on just kind of more generally kind of where the collaboration might lie. The U.S. has always been extremely effective at reporting a lot of the way that energy works, whether that is through emissions reporting, whether that is through the volume of oil that is being generated each day. That's a big part of what the EPA does, and it's very effective. My point is more that this is an area where technology is evolving very, very rapidly, and it's one of those things where it's evolving in a way where it can be employed for the benefit of managing overall emissions profiles, and so it just needs to be one of those things that is considered, or should be potentially considered, as we kind of build out additional rules around this, simply because the old systems are no longer the most effective ones. And that should really be kind of part of the way that we look at this conversation moving forward.
Thank you. Mr. Humes?
Yes, thank you, moderator. I think MOUs are a very logical approach to this. I think a very good example is an MOU that FERC established back in 1986 for LNG terminals. And this MOU established Coast Guard for their expertise around security, and then also established or recognized PHMSA for their expertise around safety. But then it also kept FERC as overall umbrella jurisdiction over LNG facilities. So I think that's a great, if we were looking for a go-by, I think that's a great go-by that has worked for over 30 years. And so that would be my recommendation for an MOU.
Thank you. Dr. Peckman?
Yes, I think that the FERC should be collaborating with other federal agencies on a number of different levels. I think obviously with EPA, because they are by far and away the keeper of the greenhouse gas emissions inventories. I think that they should be collaborating with the Department of Energy to determine what research needs that they have that the Department of Energy could fund either with national labs or any of their contractors. I've talked about accounting methods that are necessary. I believe that the FERC, to help establish a robust accounting and tracking system of offsets should be, and of carbon, should be coordinating with both the federal, the CFTC, the Commodity Futures Trading Commission, because ultimately what you would like to be able to have are offsets that are tradable and have forward contracts with them, and also the Securities and Exchange Commission, because these are going to be things that are going to be valued They're going to be reported on the books and records of firms. But beyond that, I also think that it's important for the FERC in terms of the collaboration on establishing an accounting system for offsets and carbon to be collaborating with states, the Northeast states, California, states that have been participating in determining how to account for carbon and for offsets, and also for the very many entities out there that have been trying to develop their own methods of accounting and verifying and measuring offsets as well. So there's a robust conversation, I believe, that needs to happen on the offset and accounting front, and I believe that there's a lot of activity that can happen within the federal government as well on the more physical side of mitigation. Thank you.
Thank you. Mr. Mayfield.
Yes, just kind of going back to a theme that I've heard, that we need to make sure, yes, FERC does need to collaborate with others that are already tracking this so we're not duplicating efforts, which would just be cost burdensome to the regulatory agencies and would also be to the project sponsors. And any costs on the project sponsors are going to be passed down to the consumers, and then those that can afford the least are going to be paying the most for it. So that's all things that need to be continued. We don't, if one group's already doing it, we don't need another federal agency looking at the same thing. And that's really my big issue on this one.
And Commissioner Berman?
Yeah, I would just say ditto to all of that. I think it's really important for us. I think we as the states can do a better job of sharing what we're doing with FERC. I think the federal sister agencies can also be doing that. And I do just want to point out that a lot of the key things that I think we all care about can be looked at in terms of what's already being done out there and ways that we can collaborate together more. I think the more we can do that in a way that's helpful will make us have that much more success out there. So thank you.
I see we're about out of time for the panel, but I would like to give the chairman and commissioners an opportunity to either ask a question or comment if they'd like. Chairman Glick?
Thank you. I do have one question, and this is more of a practical question about how we would implement a program. So generally, FERC has jurisdiction over the pipeline when it's being planned, when it's being constructed, and then a little bit afterwards, sometimes maybe a little bit longer than a little, after reclamation is done in terms of meeting the conditions that are in the certificate about reclaiming the land. And sometimes it's done better than others. But putting all that aside, we don't necessarily keep an active eye on the pipeline over the 40-year lifespan or however long the pipeline is in operation. If we were to impose a mitigation condition in the certificate, they have to mitigate your greenhouse gas emissions on an annual basis over 40 years. How do we monitor that, given the fact that we don't actually, oversee the pipeline for all that time? Is that something we should work with another agency to essentially hand them over that responsibility, or should FERC keep it and continue to monitor? I'm just curious if you all have any thoughts on that.
Mr. Hughes?
Yes, great question. Well, and I think, so we're already reporting our GHG emissions, both stack emissions and natural gas emissions to the EPA, and so I think that's kind of what some of the other panels were getting at earlier, is we already communicate this information to the EPA, and so it's already readily available, and so through an MOU would establish FERC's overall jurisdiction, but then the EPA could send that information to the FERC, and then they could monitor emissions and also monitor whether we're adhering to our mitigating measures or not.
Commissioner Berman?
I feel like sometimes, and this happens to me as a state regulator too, is we're trying to solve a problem by taking it on, and perhaps the issue is we can actually look at what's already being done and who's already handling it well, whether it's in industry or at the state level with state regulators and other entities, and make sure that we are not actually getting in the way of that good work and how we can help facilitate it. One of the things for me is also then asking, FERC asking themselves, is this something, and how are there possibly other alternatives to get that? And what do we need to do to feel comfortable in letting somebody else address that issue? EPA can be a partner in helping you feel comfortable. PHMSA can be a partner. DOE, who's involved in a lot of the different grants at this level as well, and maybe helping them feel comfortable. A lot of times what happens with the state PSC and our environmental regulator, it's a chicken and egg approach. We do something because we need it for reliability, but then the DEC needs to be the ones to give the permit, and then they never get the permit, or they do, or they wait for FERC to deny it or not act. And so it's like, at the end of the day, everybody needs the certainty in what we're doing or not doing and feeling comfortable. And maybe we need to have better communication among the state and federal regulators in terms of what are the ground rules and where are we going, so that people can then respond in a way that makes sense rather than what I feel is very disjointed and confusing and just everybody kind of pointing the finger at everybody else. I'm willing to work on that. I think we can have solutions. I will say we all want a better, cleaner energy future, but we've got to also make sure that we are doing what we need to do from system reliability. And if gas is needed for the backstop, we need to make sure that we have that. We cannot cut corners in what we're doing. It's too important for us and all that we care about. So thank you.
Mr. Mayfield?
Thank you. First of all, I agree wholeheartedly with what Commissioner Berman said. We all want a clean, reliable energy future. And when it comes to transmission companies, distribution companies, no one wants methane leaks. Methane's where the money's made. So everybody wants a tight system because a tight system ensures you're making the most bang for your buck on your product. And I think a way to, do it without FERC having to get involved on the back end, say, is to encourage and incentivize people to follow programs, best management practice, as in One Future, as in the Natural Gas Star program, and maybe incentivize that in some way. If companies show they're doing that, there's something in it for them. I'm not sure exactly how you could do that now to be a reduction of what they have to report on greenhouse gases, because as you're following best practices, you're going to have less greenhouse gases. But other than that, I think EPA does a good job on the downstream side. And again, as we're on that side, if you're following best practices, you could have a reduction in your greenhouse gases. And I think quantifying that will show how those programs are working. Thank you.
Dr. Beckman?
Yes, I think that it's important, and I think this has been one of the themes of this session, of coordinating the equities of other federal agencies. But having said that, I think that one of the ways in which the FERC can coordinate with those equities, to the extent that other agencies and even state agencies have a role to play in terms of overseeing the mitigation and whether or not that's continuing over the life of the project, is to make sure that the kinds of reporting requirements, both technical and paper, are part of the license permit, so that it's codified as a requirement, with respect to whatever permit is provided, and that may involve coordination with other agencies to say what more information is it that you have the authority here, but what more information can we order that would then provide you with what you need to do your job better.
Chairman Glick, did you have any other follow-ups? Commissioner Dancy?
No follow-up now. Thank you.
And Commissioner?
Not here. Thanks, Sarah.
Okay. It looks like we have reached the end of our panel, so I'd like to conclude by thanking all of our panelists again. We really appreciate your participation this afternoon. So thank you very much, and I will turn it over to Chairman Glick to give any closing remarks. I believe you're on mute, Chairman.
Thank you. Still doing that even after all these months. But thank you so much, Cyrus. I wanted to start by thanking all the panelists, both on this panel and the other two panels. I think we had a very interesting day. I want to especially thank Commissioner Berman for participating and for hanging in there, and really wish you a speedy recovery, and appreciate your insight into all these issues as well. And I also want to thank the staff. And I said this yesterday at the commission meeting, but people don't realize when they just attend these technical conferences or watch on video how much work goes into it. And we've been having quite a few technical conferences lately, so we've been stretching the staff a little thin, and I apologize for that. But these are very interesting discussions. But and thank you all for putting together excellent panels and very good questions. Just a couple quick comments, and I'll turn it over to my colleagues for their closing statements. But first of all, I think in terms of today's discussion, it was pretty interesting. I think we, for the first panel, I think for people that were watching, I think people recognize there's maybe a difference of opinion about the Commission's legal authority in terms of imposing mitigation on greenhouse gas emissions. From my perspective, the law is very clear. The court decisions are very clear. The D.C. Circuit's been very clear. I mean, I think some might say, why don't we wait for the Supreme Court to overturn us? To me, that's not our role here at FERC. Our role is to follow what the courts tell us. And in this case, the D.C. Circuit has told us that we can, in fact, mitigate greenhouse gas emissions, and that we should, in fact, examine the impact of these greenhouse gas emissions on climate change when we pursue our proceedings in terms of determining whether a pipeline is in the public interest, or a proposed LNG facility, for that matter, is in the public interest. And so I think that's why this whole day has been very important, because we haven't been doing that at the Commission. We haven't been, in my opinion, living up to our responsibilities, our legal responsibilities on this issue, and we're hopefully going to be doing that soon, and we'll have to see how the votes come down. But in my opinion, we need to move forward with this. So we need to figure out the best way to do it, the most efficient way to do it. Obviously, the least, the ones with the least impacts in terms of cost and administrative hangups and so on. But I do think we can get there. I think there were a lot of interesting solutions provided today. I would just say that as I started out the day, I think the biggest issue here is certainty for stakeholders, certainty for project developers. And I think we've created a lot of uncertainty over the last several years. My goal, through hopefully the proceeding in which we're hopefully going to have a revised policy statement in terms of how we pursue certification of natural gas pipelines, will address this issue as well. And I'm hoping that we can get to that much sooner rather than later. So with that, again, I want to thank everybody, and I want to turn it over for concluding comments and go to Commissioner Danley next.
Thank you, Mr. Chairman. I want to point out one thing about the legalities here, which is that even were I to concede that the NEPA analysis required under Sable Trail is as broad as you, Chairman Glick, have said before, which I don't concede that. We can't conflate the question of what our NEPA analysis must include with the question of what our authorities to condition certificates actually is. And I see no mechanism by which to enforce these mitigation regimes that have been discussed, many of them very aggressive today, many of them, let's say, would represent non-traditional employments of the Commission's powers. I see no way other than the conditioning authority by which to enforce these mitigation regimes. And as to what NEPA requires, that is a completely different subject from what the mitigation regime can or should look like. And I really do believe that these legal questions are fundamental. They should be determined in the first instance. They're dispositive. Anybody who knows me can imagine that I was rather taken with Commissioner Christie's suggestion that we have live oral arguments, which, by the way, is something the Commission has the power to do. I am all for it, so I lend my voice to his in asking for such a thing. But the point is, I think that moving ahead with any of these policies in the absence of having hashed out exactly what our legal authorities are is not wise and will simply serve to confuse an already muddled area of the law. That's it. Thank you, Mr. Chairman.
Well, I'll take your concession at the beginning of your statement, and we'll move on from there. But no, thank you very much, Commissioner Daly. I was just kidding about that. But Commissioner Clements?
Thanks, Chairman Glick. I think no matter what happens, this will be litigated. That's an unfortunate reality of the state of affairs today. I think one thing that you asked at the end of the first panel, Chairman, which I think is a really important, the big piece on which we have now a really fulsome record, is how do we figure out need and what's the order of events that take place in providing a framework that can be legally durable, but also matches the context that we live in today and the challenges that are facing the industry today. So I appreciate a lot of the informative and complex comments that have been provided today, and I look forward to processing them and then going back to the record on many of these issues, as well as hopefully hearing from others post-technical conference. So thanks so much to you, Chairman Glick, as well as to staff, as you said, for the hard work in getting this done. And have a nice weekend.
Thank you, Commissioner Clements. Cyrus or Brandon, do I turn it back to you all to take us out of this?
Sure. Thank you, Chairman Glick, and thank you, Commissioners Danley, Clements, and Christie for your participation in today's technical conference. We'd also like to thank all of our panelists. We greatly appreciate you taking the time to speak with us on these three very interesting and thought-provoking panels on this topic. We'd also like to note that on November 16th, the Commission issued a notice soliciting post-conference comments in docket number PL21-3. All stakeholders are encouraged to share their views on these important topics by December 14th. Finally, thank you to the FERC team that put this conference together. It includes staff from the Office of General Counsel, the Office of Energy Projects, the Office of Energy Market Regulation, and the Offices of External Affairs and Executive Director. I'd also like to particularly thank Catherine Liberty, who not only co-moderated our first panel, but also was really the driving force behind making this such a successful day. So with that, this concludes the technical conference. Thank you, everyone, for joining.